So there's that closing disclosure, and it just marches us on down through here, showing you each individual. Don't let this freak you out. I know it's kind of intimidating that it relies on about 14 different calculations to get the last result, but you've done all of those individual calculations. Now, I know some of them might be a little more concerning than others. Interim interest is always the anomaly, because you have to remember who pays for the day of interest when it's interim interest calculation. Tell me in the chat, who pays for the day of interest in interim interest? Yeah, and you know what? The logic is pretty profound. It's pretty solid. Why is it the buyer who pays for the day of closing on an interim interest question? Why does the buyer pay for it? This might help you remember this thing, because it's only the buyer who's involved with it. Because interim interest is not a proration, has nothing to do with the seller at all. So of course they're going to have to pay for every bit of it. There's no need for the seller to be involved in this. This is about the buyer's new loan. The buyer's new lender says, hey, so glad you picked us. You could have picked any lender. Welcome to the family. Here's our gift to you, a toaster, and you get to pay for 3 hours that you own the property on that very first day where you sign papers, or 12 or 8, right? Because you're not owning it for the whole first day of closing. They're only owning it for half of the day at the most, right? Because they're probably closing at the very latest 2 or 3 in the afternoon. Doesn't matter. You get to pay for the whole first day. Didn't intend for that to rhyme, but I'll try to write that down. Maybe I'll use that. In fact, you pay for lots of things. The seller pays for the payoff check to ride the FedEx truck for a couple of days too. They don't just charge them for the payoff. They also charge them to overnight it, and they want to calculate interest with enough days for it to arrive to them. Don't worry about that. You won't be tested about that in pre, but it's sort of a thing out in the real world. By the way, don't think that any of this math is going to mess you up from being able to properly do this business, because most of this, especially this closing math, the paralegal does it. I would say the attorney, but we all know that's not what's happening. The paralegal's doing this. They're plugging it into the program. There's some sort of special program, I'm sure several that they pick from, and they just plug it into the fields, hit the button. They could still put it in the wrong field, and I've had that happen. We all have. I'm sure Renee, Margie, I'm sure we've all caught mistakes on closing statements. Have no doubt. That's what our job is. Part of our job as brokers is to check behind them. That's why we need to know how this works, so that we can do this. But in real life, you don't have to calculate discount points and then plug them into the proper space on the closing disclosure. You do have to do it in post licensing though. So they get you through post, but after post, you're kind of okay. In post licensing 302, it's about closings and contracts. So you will have to still calculate this stuff. You will have to plug it into the right spot on the closing statement, just again, so that you understand how it works and why it works. But our only obligation as brokers out in the wild is to check behind them, make sure it's done right. It's easy to mess it up. Are we crediting or debiting? That's the difference of like another inch on the page, right? Just putting it in the wrong column. So we make our way on down through. We'll go through this in a little bit. And it just kind of highlights if you like circle formulas or if you like linear math, you can see which way to do it. And we're keeping a tally on the right. So there's one for a $450 purchase price and there's one for a $300 purchase price. Very similar, but all the math calculations are different in numbers. That's what we saw already. Oh, I gave you some practice problems years ago. Remember that? Remember so long ago when we were all just babies? We just met each other back in middle school like 9 weeks ago. And I made up some practice problems for tax here for you. So don't forget about those. If you can read them, I have the writing of either a genius or a serial killer. I'm not sure which one that is. We've got our residential square.
Definitely genius.
Some serial killers were geniuses. Apparently, that's sort of the new guilty pleasure. I'm watching the documentaries about those folks, trying to see who's looking weird in the Target and the Walmart. You gotta know what you're looking for. Boy, that'd be rough. Some people might get accused of being serial killers in Walmart, and they're not. So don't judge books by covers, right? Here's a book to take a look at. We looked at it last time. We want to just make sure that you review about square footage. Since it was our last time together, let's talk about it. What are we measuring when we measure square footage? What part of the house are we measuring? Are we measuring inside or outside? Yeah, exterior. So 1,800 square foot house means part of that is insulation and studs and siding. And bricks are like 4 inches wide, plus the 2x4s are 3.5 inches wide, plus the insulation and the sheathing. You're losing probably 8 to 10% of that 1,800 square feet just to insides of building components, but it doesn't matter. That's how we do it. So we're pulling tape on the outside of the structure. And then the next important thing is how much of that is heated space? We have to differentiate the heated space. Heated. Doesn't say cooled space. It just says heated, HLA, heated living area. And then also it could be heated but not finished. We have to differentiate that too, because we don't want to just have this wide open, no sheetrock concrete floors that are never been polished or finished and nothing over them, but it's heated. And we told you it was 1,800 heated, but come to find out there's no actual separation of rooms. It's not finished. It needs to have walls, needs to have sheetrock, needs to have carpet or some sort of maybe wood floor or tile. So it also needs to be directly accessible from other living area. 2-story home in the 80s, you'd see this sometimes. You go upstairs and you see a master and you see a couple of bedrooms and bathrooms and hallway, maybe even a bonus room. But if you don't see the bonus room, but there is a garage, you think, that garage looked like there was enough room over it for there to be a bonus room. And you might find out that you can't get to it from the main living area, the main HLA. You have to go out to the garage, through the cold garage, to the stairs. Anybody cold this morning? Anybody step outside this morning? How did it become cold? I'm glad for the bugs to die, but now I got to pull out coats and jackets. Oh, poor me. It's not that. It's when I get home and I've got a pile of laundry by the door because I'm too lazy to hang up my coats. And I didn't want to use this coat today. I wanted to use the other coat. Anyway, directly accessible HLA has to be counted properly. You've got to specify, 500 square feet of heated living area is only accessible through the garage, through some unheated space to get to it. You can't just lump it all in together. If it's below grade square footage, we have to tell them so. We can't include that either without specifying, look, this is below grade. And when you're doing your calculations, you have to allow for that too. If it's a 2-story house with a basement, 2,500 feet on the main 2 levels, and then another 1,400 feet in the basement, you don't multiply the same dollars per square foot by the heated living area as you do the basement square footage. You can't use the same number. So if you figure out that the dollars per square foot of value for a house like this is $114, then you would need to discount that down. And different appraisers have different rules of thumb, different guides on how much do you count for a basement? It's undergrade. Is it finished or not? All of these things come into play. That's why this is probably one of the first skills you want to work on once you actually get up and running with your license actively, is start practicing this stuff, studying this stuff, and figuring out what these values should be. How much is a bathroom worth? There's no magic formula. There's no magic answer sheet for every house. It depends on the neighborhood, depends on the area. A bathroom in my area is not the same as a bathroom in Margie's neighborhood if I had to do a CMA for something where I live versus where she lives. The other big thing on measuring is the stairs. Even though there's space under the stairs that you can't get to, And you would think, well, if you can't get to it, why should you have to count it? Sometimes we don't ask why. Sometimes we just do what they tell us to do. We're going to count every bit of the square footage under the stairs as well. Even the parts you would have to get down on hands and knees to access. Sometimes it's got a scuttle hole and you can actually throw some holiday decorations under there, but sometimes it's all even cut off. You can't even get to it. Doesn't matter. It counts too. So if it's a 2-story home with stairs, as we'll see in one of these pictures here, and the stairs to get to the upstairs, there's a hole in that upstairs floor that perfectly fits the dimensions of the stairway. In other words, you can't look down into the foyer from up above. Well, then this is just going to be measuring the entire exterior of the downstairs, figuring out what this dimension is on the upstairs and counting it all. You don't subtract this little 3-foot wide by 10-foot long stair piece. You leave it alone, you leave it in there. The other thing is addressed in this diagram, looking for at least spaces with at least 7 feet of headroom. That's counted as heated living area. Sometimes there's pipes and ductwork running that bumps down to 6 feet 4, and if that's the case, that's okay. You can still count this entire area, long as it's only occasionally that the 6'4" minimum. If it's less than that, then you need to account for it. But they do let you have some pipes and ductwork in the way. And then the the angled ceiling bonus room. Let's see if I find one here. Well, how much floor space do we count when it's a room that has 2 angled ceilings, like a cathedral ceiling where both sides are angled? Maybe, what if the angle goes all the way down to the floor? Do we get to count that entire width of floor? How much of that width of floor do we count? As I draw something out. There you go. Thank you. 5 feet. And oh, that's what I'm doing. Okay, I got you. There we are. Here's our cross section of an angled ceiling bonus room right here at this 5-foot mark where the height up to the ceiling from the floor hits 5 feet on both sides. That's where we start measuring. We measure from there to there, not from here to here. We ignore this part. We do not count that part. That's the rule for the bonus room. That's about it for square footage, unless I'm leaving something out. I don't think so, though. What part of what is it? What is square feet when it comes to the requirement of the real estate commission? What does the real estate commission require with regard to the square footage? Is it a material fact? Is square footage a material fact as per the real estate commission? Yeah, they don't require it. They don't require it, but because the MLS does, therefore we have to put it in. The real estate commission says, well, hey, don't forget about us. You got to make it accurate. Be sure it's accurate. That is square feet. What else? Let's talk about license law and commission rules. And here is when you need to you've probably maybe marked up your syllabus by now. Hopefully you've made it a nice study guide. You've put little notes and things along the way. You've referenced pages from the textbook. You've highlighted some things. You've written in some definitions. Maybe you have a notebook plus a syllabus plus all the notes in the margins of your textbook. You have all of these things. Now it's when you put them all together into this big, impressive review arsenal, so to speak. and maybe print out a new syllabus, a nice clean one, or just look at this one and then write a new fresh page of notes and just, it'd get a little tedious, but you could say like Roman numeral 21, license law, commission rules, A1, basic. That'd get a little old. I'd probably print out a new one and then just try to fill it in from memory, right? That's sort of a boot camp hardcore review for yourself. How much of this do I remember? What are the basic licensing requirements? Well, for one thing, if you don't, when you try to answer it first. If you can't, click on it. Just click on it, and then there it is. It'll pop up in your browser, and it's right there. You know it. What are the basic requirements for licensing? When do you have to have a license? If you're doing what for who? Real estate for money or some sort of compensation for other people. You got it. Next part is, what is real estate? Yeah, listing, selling. What else is real estate besides listing, selling? Auctions, that's a good one. Leasing, you bet. Property management. Yeah. Referrals, that's a little known, but a great way to make money. Great side benefit of having that license. Good job. And just that all the way through this thing. Categories, provisional versus broker in charge. Note the warning I gave you on the first day that they're showing to you here in this syllabus. They didn't say provisional broker and non-provisional broker. I'm kind of glad they don't, because I think the provisional part would really sort of get confusing. But on the test, just be aware that if all they say is it's a broker, then they're talking about a full or a non-provisional broker. If it's provisional, they will say provisional. But don't let the fatigue of the test after hour 2, because by the way, you'll be taking the state portion when all this stuff happens. You'll be taking that last. You will have already spent 2.5 hours on the national before you get to the 1.5 hours worth of state. So take a breath, center yourself, and think provisional is provisional, full is full, or just no, it's just going to say broker. Don't mentally put in the word provisional when you see the word broker by itself. And there's also this animal called a broker in charge. And there's also one called a broker in charge eligible, right? BIC eligible. So the differences between these three is covered in this license law, 93A-2. Aren't you glad you don't have to know the numbers and letters of the laws? You can just click on them. But it's good that they're there. So I like having I'd have the printed version to write on. I'd have the PDF version like this, so you could just click and get to the law or the rule real quick. Have the textbook, have the notebook, paper set outside. Limited. Oh, by the way, provisional broker. What does it take you provisionals, once you become one real soon, to become a non-provisional? How do you get rid of that provisional label? There it is. You've heard it enough. You're tired of it. You get rid of the provisional status with post-licensing courses. Not CE, but post-licensing courses. It is very easy to mix up the whole CE requirement with the post-licensing requirement. So be aware of that. So let's look at something that might help with that. If you need to, by the way, start making, if you haven't been doing so, hopefully you have, make lists and charts. Lists and charts. CE. And post licensing. What's the difference? Well, post is to get from provisional broker to full broker, or plain just, non-provisional broker. Post is 3 30-hour classes. You've already told me that. Post is to get rid of your temporary status, right? It's to shed yourself of your temporary provisional status. Post can be done even if you're still inactive. I've had plenty of post students who never got their license activated because they just wanted to get all the education over with, come into this thing, hit the ground running with full broker status. And then CE, that's for everybody.
No,
Hey,
so we can take our post classes like immediately afterwards, and we don't have to
yes.
get affiliated with a broker.
Now they've changed it a little bit, and I'm not sure. Maybe the ladies could help me with this. There used to be a requirement that I forgot what the requirement is, but do you have to have passed or taken the PSI before you take post? I think that's the case. Yeah,
Yes.
Margie says
Yeah.
yes. Okay, and that
Yes.
makes sense because
You
sometimes it
just
might
don't have
take a
to be with
time
a
or two.
broker.
Say again.
You just don't have to be affiliated with a
Right.
broker.
Exactly. You do
Okay,
not have to
okay.
be
Oh, that's
activated.
that's good.
Yeah,
Okay.
that kind of helps you kind of get something done before you're committing to, because once you do go active and you join a firm, now they're going to want you to probably join the MLS, join the realtor board, outlay some money, in other words. So maybe if you want to watch that money in the beginning, you spend it on the post because you have a real job. I call it a real job. It's a W-2 salary, guaranteed, be there every day job versus this where you get paid when you sell something. Then that makes sense. I totally get it why someone might want to do that. But CE applies and is required of every broker. There is a little asterisk, there's a little caveat here on CE with you. Once you get your license, do you have to take the very next June 10th CE deadline? Do you have to take CE by the 1st June 10th after you get your license? You do not. What would be the point, right? That's their logic. That's the commission's logic. You've already learned all the rules and laws. There's nothing in CE that you would have really benefited from. So that's just a little perk of being a brand newly licensed agent is you get to skip your first June 10th. I don't like to say skip your first year because it might not be a full year before the CE, right? It might only be a few days. If you fire this thing off and activate it like in May, then your first June 10th that you get to skip your CE on is in like a month, right? And so therefore next June 10th, you're going to have to take that CE. By the way, anytime between July 1st and June 10th is when you can take CE for a given year. July 1st to June 10th, because July 1st is the beginning of the license year, of the real estate license year. What else about CE? June 10th is the deadline. June 10th. Deadline. What happens on June 11th if you wake up and realize you forgot to do your CE by June 10th? Are you still active? This is a tricky one that I get people in CE classes all the time. I ask everybody, post students, 10-year veteran students who are in CEs. They all get it wrong. Not all of them. It's easy to get this wrong, but from June 11th through the 30th, you're still active. But the train is coming down the track and you can see the light. Because on July 1st, if you missed June 10th, you're still active for 20 more days, then you absolutely will go inactive. But you're not inactive yet on June 11th. June 11th, you're still good. If you could maybe get everybody on your client list to hurry up and close in the next 20 days, then you'll be okay. Maybe you could take a breath. I'm just kidding. You wouldn't put the client's needs above your own, right? Obviously. But there are a lot of panicked faces in CE classes that are given on the first week of July or any week in July, probably, because that's when the sort of recovery classes are happening. Also, during that 11th to 30th day or period, we schools are not allowed to give you classes. We can't teach CE classes. We're not allowed to. The Real Estate Commission is taking a break. They don't want to check our school records and say, yeah, okay, people took classes on the 11th through 30th. Nope. They're taking a break too. They're not at the beach. They're resetting for the new license year. They have to cycle through files and all the mad rush of people. Guess what? The most active part of the CE environment or atmosphere of teaching is between, I'd say, March and June 10th. A lot of people put it off. And as a business practice, I would suggest to you as a new agent getting in, don't do that. Sometimes the CE classes actually have useful information. They usually do. So let's go ahead and learn that before the whole year goes by. Maybe it'd be nice to learn whatever they want us to know for that upcoming CE before we have to use it, instead of at the last minute when we had to learn by hearsay from our broker in charge and from other brokers. There's some pretty important changes that happened in the last couple of years. One of them was a redo of the paperwork for the Working with Agents brochure. Because see there, I just used the word from the old days. It's not a brochure anymore. It's a form. It's an actual page. The brochure is gone. It's relabeled questions and answers. That's what the brochure is now. It's just a follow-up support document. But now it used to be we signed the brochure. We got our client to sign the brochure. We'll talk about Working with Agents review here in a second. So CE, June 10th, that's the big one. Oh yeah. What's the deadline for post? What is the deadline? If June 10th is the deadline for CE, the deadline for post is what? Yeah, 18 months from date of licensure. 18 months from date of licensure. And Janina had a good point. If you don't do the education, whether post or CE, then you go inactive. Your license goes inactive. So education or affiliation is what active versus inactive is about. And then paying that money, the dues, is what expired is about. Your license is expired if you didn't pay your money. When is the money due? When's the $45 renewal fee due? There it is. Just like any bill, the day before the due date, right? The due date is the very last day of the period. So the 30th, June 30th, you just do it online. You'll never be able to, I doubt they would ever let us do this automatically. Plenty of agents have been like, can I just give you my card? And it happens automatically and I never have to think about it again. No, because the commission is doing more than getting your money. They're making you answer some questions every year. Are you really doing this as a 1099 instead of a W-2? Have you, they just ask you some stuff to kind of get it back on the record again freshly every year that you know what you're supposed to be doing. It's 2 or 3 questions they have you check off and answer, and then you can pay your $45. Back to the syllabus. Then we have this thing called I guess we talk about broker in charge. What does it take to become a broker in charge? A 12-hour course. First of all, though, experience. How much experience do you need to become BIC or BIC eligible? Either 2 years full-time or 4 years part-time. It's actually counted in months, 24 months total. And the formula is not, it's just a combination of things. They want to be able to prove, did you really spend 40 hours a week full-time in real estate? Show us your transactions. Show us other things. It's more than just give us a list of your transactions. They want, if you held a job as a full-time mortgage broker that whole time, are you really expecting us to believe, and I'm talking as the Real Estate Commission, expecting us to believe that you spent 40 hours a week as a mortgage broker and 40 hours a week full-time as a real estate broker for experience? We probably aren't going to believe that, right? And I had a mortgage broker, that's why I used that particular job, who asked me in class and realized that I could see it dawn on his face as I answered. He's like, oh, man, because he wanted to kind of double duty it and then be able to get his own, to get his broker in charge status so that he could start his own firm while the whole time along he was being a mortgage broker and paying his bills. You can't really get full-time real estate experience if you're not doing it full-time, can you? It's going to take longer to get the same repetitions like in the gym, right? going to take longer to actually have enough transactions under your belt to have the experience required to be an effective broker in charge. That's another level. As a broker in charge, you're over everyone, meaning you're supportive. You're being supportive to everyone. In fact, the commission also says we don't want a broker in charge who has never had a bit of commercial experience. We don't want you to be BIC for a commercial broker. If you got commercial brokers under you, you better have commercial experience as a BIC, because you need to be available as a resource for these brokers, even the non-provisional ones. So the provisional ones and that BIC, that relationship is special because they really need to know everything about your transactions. If you're having troubles, it's the learning curve, right? It's only at the most 18 months, and some firms actually require it to be less. Some firms say, we want you to get that post done quicker than 18 months. That's a good question to ask when you're on interviews with the firms that you might join right off the bat. They might even they'll probably tell you, look, by the way, are you going to do this? Take it seriously. You can do this full time or part time. It's okay either way, but just know that you've got to get that post done maybe sooner than what the real estate commission requires. So it's experience. It's the 12-hour course. And if you take the broker in charge course, the 12-hour course, if you go ahead and take it, once you take it, you have 1 year to declare yourself BIC eligible or BIC. If you go ahead and declare yourself broker in charge, because maybe you got hired, some company needs a broker in charge and they hired you real quick, you can do that as long as you have the experience. But you got to take the course within 120 days so that you can hurry up and learn how to be a BIC. But they let you be one first, but only for 120 days within which you need to take the course. That's about it for that one. Limited non-resident commercial broker. Just a anomaly, sort of a thing we only do in commercial. Nice long name, has all the answers in it, right? It's for commercial only, not residential. It's for companies to be able to send their real estate person here to North Carolina to do whatever they need to do to expand. Maybe buy another location to expand into North Carolina. They have to be under a North Carolina firm so that they'll know what laws and rules are. And it's just for the commercial purpose. It's limited. It's non-resident. They have to be an active broker in their home state as well, right? They can't just come here under this without having that broker license. They also have to have that. And it shows up in lots of, let's see, we've got a license law spot where it shows up. We've got several commission rule areas within which it shows. All of these 58A things are commission rule sections, and the 93A stuff is the license law section. Licensing of business entities. What does that mean? What are we talking about? What's the gist of this note here in the syllabus? Licensing of business entities. Yeah, you choose to form an entity, then it needs to have a license too, because if you're going to do real estate in the name of your LLP, LLC, S or C Corp, then it's doing real estate for other people for compensation. Therefore, it needs a license too. That's what a firm license is. Firm license is the license of a firm, not a human. There has to be a human attached. But I, for instance, have a firm of my own. My firm has a license because I do all my real estate in its name, not my name. And I pay $45 to renew Neil's license, and I pay $45 to renew the firm license. And then this Section 3, activities requiring a license. We saw that on the first day too when we did our little preview. Listing and selling, no surprise there. Leasing, auctions, you've told me a lot of these things. Selling, buying, leasing, exchanging, any interesting connection with the purchase and sale. Might be a 1031 tax deferred exchange that you're involved with. You're not doing anything about the exchange portion, but you're doing the real estate side. You're helping them find and procure property, but because it's a 1031 exchange, it's got to be done in a certain time period. If it's not, they won't get the benefit from the IRS of it having been an exchange, right? They're able to defer taxes, but only if they do it within a certain number of days, which you don't need to worry about for the test. Just know that you need a license to help people with real estate, period, whether it's involved with all of these things or not. Or if it's involved with all of these things, I should say. And then the referral fee. We had a nice big list of things unlicensed people can do versus not. We had some exemptions, meaning you don't need a license to do real estate if you're in one of these situations. If it's an entity selling entity real estate. Anybody ever watch Chip and Joanna Gaines, by the way? Everybody remember them from Waco, Texas? I saw a new thing they've got. They're redoing a castle. Did you see the castle? They got a castle in Waco and they're redoing it. And I think the first episode is out. So it's current again. So I bet they own that castle in their little Magnolia entity. I doubt it's a Chip Gaines castle. I bet it's a Magnolia castle. Therefore, when they sell that castle in the name of Magnolia Properties or whatever it is that they call themselves, they are licensed agents, but if they weren't, they could still do it because it's the entity's property that they're selling, right? So business entity selling or leasing entity-owned real estate, sort of like a for sale by owner can sell with and not be an agent. An attorney in fact versus an attorney at law. The difference between a power of attorney versus an actual attorney. Anybody can be have a power of attorney and be what's called an attorney in fact. That just means somebody asked you to sign on their behalf. They filled out paperwork saying she is going to sign this for me. She is the same as me when it comes to this power of attorney. I'm giving her basically the power of being an attorney for me. And that's what they mean by attorney in fact, because that's how you sign things when you have a power of attorney for someone. You might sign, you could do that as a broker. It's not recommended because you just want to make sure that you're signing what they want you to sign and what they agree with. And the bigger the document, the more area for problems. I did it one time. It all went fine. I don't want to do it again because it was for a couple and it was for purchasing. And for each signature, I had to write Neil Pender as attorney in fact for John Doe times 1,000,000 pages. And the same for her as well. So it makes your hand tired. But that's what an attorney in fact is. When you are given power of attorney, you can do real estate for other people for compensation. But you're exempt from needing the license because you're doing it sort of in their name as them. And then an attorney can do real estate for other people for money because it's attached to their law side of things. They're doing legal business for you, and part of that legal business involves a piece of real estate. They can do real estate for you without the license because it's attached to the legal business they're handling.
Neil,
Yes.
the attorney in fact, is it just for South Carolina for North Carolina, or is it a national thing?
Good question, but all we're talking about in this entire book of license law and commission rule is North Carolina license law and commission rules. So I can't answer that. I really don't know. But I think it is nationwide that you can have power of attorney for other people. So I bet it's some version of it is available in other states, if I had to guess. If you're a guardian for somebody, I sold a house that was a sad situation. It was an executor situation. The owner had passed away. He had 4 daughters who were of legal age. He had 1 son who was 12. And so because the owner was deceased, I was also dealing with his brother as the executor of the estate. So a brother of deceased, daughters of deceased, 3 of them, plus little boy son of deceased. And had a lot of signatures to get on lots of paperwork because there's a lot of people involved. Well, the son was underage, but the baby mama, the son's mama, right? They had been divorced or maybe never got together. The son's mother was his guardian. So she could do real estate for her son without a license because she was the son's guardian, right? The son was being given his share of this property along with his 3 sisters who were of age. It was creative. I had to get 3 sisters' signatures plus ex-wife's signature on behalf of son. A trustee can do real estate without a license. Salaried employees. We saw this one with property management. those W-2 salaried employees that work for a property manager, well, that property manager is a broker. They have to have a broker's license to manage property, but they can hire unlicensed people to help them do it. And those salaried, unlicensed people can do real estate without the license when it's this situation. They're doing it for a property manager broker. They can show rental property. They can execute leases on behalf of their broker boss. You can't execute a contract out in the wild without a real estate license, but you can execute a lease if you're a salaried employee of a broker boss property manager, right? Individual property owners selling or leasing their own stuff, FSBO, FLBO, FSBO, you can do your own real estate. You don't need a license. And then if you work for a housing authority, you've got to do real estate stuff connected to the housing authority business. You don't need a license because it's part of that business. And I bet you're being paid a salary. So it kind of looks like a parallel of this one too, doesn't it? Kind of looks like that whole thing where that's allowed under property management. Commission, making our way on down through. I'm sure you've done great so far. The composition of the commission. Who are the commissioners? The appointed, not elected, but appointed commissioners that serve 3-year terms. How many of them are there? 9 of them. Good. Got that the other day too. 7 of them appointed by who? Who appoints? Trying to mute my slurps. So that's why I'm cutting in and out on you. The governor appoints 7 of them. One's appointed by the North Carolina House. Another's appointed by the North Carolina Senate pro tem. And 3-year terms. How many commissioners have to be in real estate business minimum? What's the minimum number? 3 of them. And how many must not be in real estate? At least 2. And obviously different combinations over time. You'll never have a whole array of 9 brand new commissioners because it's a 3-year roll on and roll off kind of situation. You could have a brand new governor get elected, and one of the duties of that governor is, oh, wait, this year we need to add 2 more commissioners to the real estate commission. And then they'd see who needs to appoint and decide from there. Purpose and powers, what do? The commissioners make decisions on all sorts of stuff. What are some of the things? Yeah, they're not paid either, Ashley. That's right. It's for the privilege of doing it. Yeah, education is one of the purposes. They oversee what's required. We had a lot of that going on in these last 3 years with that illness which shall not be named. We had to figure out how to handle that when people weren't allowed to be out amongst other people. And back on that year, we actually, one of the decisions they made was to delay the deadline of CE by 6 more months, gave everybody more time. It also, they had to come up with rules about this sort of environment, this Zoom environment. What are we going to do with Zoom? Oops, I've been faceless this whole time. And then, of course, discipline. Big one, Shane. The one we all try to avoid, right? Every month we get a bulletin. I think I might have shown you one of those bulletins. And I say in the back of the bulletin because they used to print them and it was put in the back of the printed, but now it's a PDF or it's actually a website page. And a section of that bulletin has disciplinary action. They call you out. They say this agent, John Doe in Myrtle Beach, or I guess not Myrtle Beach, in Wilmington, did this thing. And they talk about what they did. They don't go into great detail, but they say they were reprimanded. They were given a reprimand, or they were suspended. Many times they'll say they were suspended, but we suspended the suspension. You're going to be suspended if you don't do the things that we're asking you to do, like take education courses to get better at whatever the thing is you messed up on. I don't want to mess up on the break, however, so let's go ahead and take a 10-minute break. Welcome back. Welcome back. Hope it was a wonderful break for you. Hope you got some traveling done. Let's keep on going through this syllabus. Is this useful? Maybe it makes the syllabus not quite so big and scary. Probably should have done this on the first day. Take those horns off of this thing. So that's what I would suggest. Just keep on going down through your own printed, unfilled out version and fill it out again, right? It's going to reveal to you really fast where your weak spots are. And there's a whole course worth of syllabus sections to do this on, right? We're on the license law and commission rules part. We left off here. Yeah, if you don't take your post classes, then you go inactive. If you're already inactive, it's just going to take more for you to activate. And we talked about expiration and renewal. Got to pay that money or your license will expire. We know about continuing ed. We know about the brokers must supervise provisionals. By the way, what we're looking at here is Section C. What is important about Section C? Do you remember what makes Section C of this Section 21 special? Everything in Section C is what is not covered in the comments section. Remember I preached and said, read that comment section 45 times. Who read it? I'm just kidding. I'm not calling you out. Hopefully you've read it many times by now, but these things are not in it. So you need to go through this Section C, if nothing else, right? As well as the comment section. It does not cover these items, but they're all the basic stuff that you probably retained and remembered from the first day. But it's 10 of them. And must be supervised. Provisionals must be supervised. Got to pay fees of $45. We know that. Proof of licensure. You have to carry around some image of your license at all times while you're doing real estate. That could be a card. Could be a little pocket card like the old days. We used to have them. Or it could be a screenshot on your phone. You just have to be able to show your real estate license if you were asked. Proof of licensure. That's what that means. If you want to see the actual rule, click on this and it will open up the link. And there it is. Proof of licensure. Pocket card issued by commission shall be retained as evidence of licensure. Shall produce a legible form of the card. Form, not the card, at least the form of the card. Back when we did them in real life, and we'll probably get back to that at some point, but when I'm doing a post-licensing class in real life, butts and seats in the room, that's part of the registration is show me your pocket card. And I would say, Margie could maybe attest to this, 80% of them look at you like you did something rude, and they're like, oh, I don't have that. We called him out on it all the time. So then we'd have to walk them through how to go to the commission website, maybe on their phone, find it, shoot it so they can show it to us. It's just part of how that goes. You can pay, if you lose it, you can pay a duplicate license fee to get the new one. A lot of people are doing that the night before CE or the morning of their CE. They got to show it for CE. Proof of licensure, change of name or address. Finally, if you change these things, you have to tell the commission that you changed them within 10 days. 10 days to change the name and address. Got to report that to the commission. What about reporting a criminal conviction? How many days do you have to tell the commission that you got convicted? 60 days. Good job. What about reporting a criminal accusation? How many days do you have to tell the commission that you were accused of a crime? How many days do you have to report an accusation? Yeah, you have forever. You can take forever to tell them that because you don't have to tell them that. None of the business until it turns into a conviction. Don't worry about this second week word. I'm experimenting with covering certain sections of this thing regularly throughout the course. I'm just kind of an idea of how to split it up. So that's future development for me, for my notes. And then this part, oh boy, here we go. The big four: willful and negligent, omission and misrepresentation. Did your tummy just feel a little bit queasy? Because we read these examples that they give us in the comments section, and we're like, oh, that sounds like makes sense. I got this. But then you read it in a practice exam, you're like, wait a minute. Wait, what? So my advice to you, if you recall, is to think about whether it is misrepresentation or omission first. Figure out the willful negligent thing second. Let's figure out, is this misrepresentation or omission? In other words, did they say or write something? Did they express something? Don't worry about if they did it intentionally bad to be evil, or if they did it because they're just slack and lazy. We'll figure that out next. Read the question, read the circumstance, decide, did they not say something they should have? That would be omission. Or did they say something wrong? That would be misrepresentation. And then, okay, now we got to qualify this and say, what kind of omission? Oh, it was omission because they were hoping they wouldn't ask. They knew they should have told them and they chose not to. Willful omission, right? Or, no, they didn't tell them because they didn't do their homework enough to know they should have told them. Negligent omission. They were lazy. They didn't even bother to check the zoning requirement. They didn't bring it up. And they didn't check. Because some of this stuff we have to discover and disclose, right? We'll look at some of that. If we click on the link, we see the disciplinary action that the commission has available to them. It's a 93A, so it's a licensed law thing. They have the power to discipline. We know this. They can suspend or revoke a license. They could also reprimand or censure. So those are the 4 that we know about. And here are all the things, the laundry list of things, 15 of them, that they could find you guilty of. In CE classes, in post classes, they'll give you a case study. Here's what someone did. Now, which of these 15 are they guilty of? And you got to go back through and say, okay, well, they did some sort of willful, negligent misrep or omission. They made a false promise. It's always multiples, by the way. Seems like they never just did one thing wrong. False promises, acting for more than one party in a transaction without the knowledge of everybody. Sounds like undisclosed dual agency, right? There's what makes it illegal. This is what makes it against the license law. Accepting commission, as a broker for the performance of these acts from anybody except their broker in charge. We got to get paid through our BICs. In fact, if another BIC wants to send you a referral fee, they need to send it to your firm, and your firm pays you. And your firm might even take a cut. That's okay too. But it's got to flow through your BIC. Representing other than the broker by whom they are engaged or associated without the knowledge and consent of the broker with whom they are associated. Failing to account for or remit monies coming into their possession which belong to others. Handling the trust money. We'll see an entire section of trust money here in just a moment. Unworthiness, incompetence to act. So you got to know your stuff. There's that reasonable skill and care, right? Old car, the last of the acronym, reasonable skill and care. Paying a commission to anybody for acts performed in violation of this chapter, improper, fraudulent, dishonest dealing, doing legal stuff, performing legal service, constituting the practice of law. We've hammered that in along the way, and there it is in the actual license law. And then here's the big commingling word, mixing our money with our client's money, handling that trust account properly so as not to commingle, right? Don't stick that earnest money into your operating account. Put it in the trust account. And then not delivering a copy of purchase agreement or offers within a reasonable time. Pretty much, when do you deliver offers? When do we have to deliver offers to our client? Yeah, ASAP, but not later than what? That magical 3 days. 3 days is all over this business. 3 days is the answer to most things. Like in Sunday school, they say, what's the answer to this question? If you say Jesus, you're right. So in real estate, if they say how many days, if you say 3 days, odds are pretty good you're right. Failing at the time a sales transaction is consummated to deliver detailed and accurate closing statement, we are responsible for the closing statement. Not all of it, not everything on it, but the stuff that pretty much comes over from the contract, the stuff that we were involved in. And here's what says so. And then my favorite one is number 15, violating any rule adopted by the commission. They just throw that in there so that let's make sure we get them. If we're doing it wrong, then by the way, you're guilty of those things plus this one because you violated some rule somewhere adopted by the commission. Okay. That covered a lot of these things. Just reading through the license law, 93A6 talked about a lot of this stuff and gave sort of examples of it. So good to read that license law and commission rules language itself, not just the comments. Remember, day one, read the comments, but don't only read the comments. The commission freshly put out a new edict to us, all of us educators, said, don't just be telling them to read the comments only. They said, we want them to read the license law and commission rules too, but it's just a nice start to start with the comments, get real familiar, and then refer over to the official rules and official laws. That's all this stuff. We just saw it. General brokerage. Let's see what some advertising rules are. A couple things about advertising. Got to have their permission to do it. You list a property, you got to have permission of the seller to advertise, and it's all built into the standard form listing agreement. All of that is provided for because it's written by the realtor board, right? So it's in there, initial here saying you're okay with me using the internet, for instance, that sort of thing. Got to have consent. Blind ads are not allowed. What's a blind ad? Tell me in the chat, blind ad. Blind ad. That's when you're making an ad for something and you're not admitting that you're a broker. If you kind of look down here, each ad shall indicate as a broker or firm. And if you're a provisional broker, you've got to include your firm phone number. Otherwise, it's considered a blind ad. If you're a provisional broker, just think about like you're just this little baby puppy, little adorable puppy, but you have sharp teeth and you could hurt somebody because you don't know quite what you're doing, a little awkward. Therefore, if you do accidentally screw up or intentionally screw up, you got to give the consumer the ability to reach out and find your broker in charge. So one reason for me, this is the best reason amongst all of them. If I were in your shoes as a provisional, I want to hurry up and get that post done so I don't have to include the firm's number in my stuff anymore. I want it just to be my number, right? Because the thing is, people call off of an ad and they call the firm number. It might be that they get into the rotation of what's called call time and they could be answered by another broker. And yeah, okay, I'm all about helping and supporting my fellow brokers, but if I can get that buyer lead myself and do both sides of the deal, if dual agency is my thing and I'm okay with it, that's kind of what that's about. So as a provisional broker, you have to include the firm's phone number. But even as a non-provisional, you have to admit that you're a broker. Neil Pender, call this number is not enough for that ad. It's got to be Neil Pender, broker with Impact Carolinas Realty. And then it can be, since I'm non-provisional, it can be my cell number, whatever number I want. If I were provisional, it would also have to include the firm number. You can put your cell number as a provisional as long as you also put the firm number too. Got to have 2 phone numbers in there minimum, or got to have 2 phone numbers, not minimum. You could do only the firm number if you wanted, but that one has to be in there in an ad run by a provisional broker. And by the way, your firm might have certain policies and procedures about ads that they want you to follow too, but this is the commission's bare minimum. And then notice there's a little note here about the limited non-resident commercial broker. They've got to make sure the ads are done right. So comply with Rule 1809, blah, 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 about all ads. So that's another reason that non-resident limited commercial broker is affiliated and kind of supervised by a North Carolina one, so they don't screw this part up either. Okay. Delivery of instruments 3 days, immediately, but not later than 3 days. Retention of records. How long do we have to keep records? When we have a closing, congratulations, you had your first closing. It might have taken you 1 month, it might have taken you 6 months or 9 months, but you have it. Now, all of the paperwork about that closing, the contract, the closing statement, those listings that you showed them, the offers you made, because maybe you had to make multiple offers by the time you finally got one, if you're a buyer agent, for instance. All that stuff has to be kept for 3 years. Good job. 3 years. It can be electronic, right? You don't have to print it all out and stick it in a moth-protected plastic bin. You could if you want. You could do it in addition too. So it could be either or both, printed version or electronic is fine. And that's retention of records. Fees and compensation. We got to tell people what we're making, that we're making money. If it's our buyer and we're showing them houses and one of those listings has a seller willing to pay us a broker bonus, that's coming back someday. I don't know when, but that once upon a time, we brokers would get bonuses from maybe a builder or a seller who wanted to try to get an advantage over the competition. They'd say, hey, broker, if you show and then get a closing with this listing within like 30, 60 days or by the end of the month, sometimes they put a time limit on it, we'll pay you $1,000 bonus in addition to this commission. That's okay, but your client needs to know this before they fall in love with it. When do they need to know it? Not just at the last minute when they might be signing the final paperwork after you've negotiated back and forth. No, that's too late. They've already kind of made an emotional investment. It needs to be as you're going in and showing it to them. And you want it to be fully transparent. You don't want it to look like you're just trying to push them toward buying that one, and then they find out later, oh, it's because she's making a bonus that she was pushing so hard. No, it's got to be you're pushing because you think that's the one for them, but oh, by the way, hope you pick this because I'm getting a bonus if you do. Right? You want to make sure that they understand there is extra compensation for you. And then whether or not you really think it's the right house for them, that's a whole separate issue. But if you are completely upfront immediately and transparent about it and they trust you, do all you can to never violate that trust. You don't want to, and the least little bit of mishandling the timing on this disclosure of bonus or extra compensation can screw it up real quick. You can really lose some points. He's just another one of those devious salespeople, like old used car salesman just trying to pull one over on me. That's what their default is, and you want to rise above that and never jeopardize it. Can't draft legal instruments. We know that. That's an easy one. And disclosure of offers. Which offers do we disclose? What about offers that come in after they've picked one? We're already under contract and somehow we get another offer. Maybe we haven't told the whole world that we're under contract yet because it's only been like an hour. Haven't even gotten in front of a computer to go into the MLS to change the status from active to under contract. But we got 3 more offers that hour. Still tell your client. Disclose and present all offers. Even if the client is someone who agonizes over every decision and it was so much work for you at midnight on the phone while they cried through the decision and you're like, I don't have it in me. Please don't make me present another offer to this indecisive person. Doesn't matter. They come first. Therefore, oh no, this could ruin everything. What if they like this one more than the one they took? Well, they're obligated to the one they took. We're under contract. But what they might want to do is keep this one that came in late as a backup offer. And that's the main reason why you need to present it to them, besides the fact that it's a law. But that's why, that's the logic behind it. Maybe they want to hang on to that when they're annoyed that it didn't come in sooner and they went ahead and took one that's not as good as this latest one. But maybe at the very minimum, they could keep these guys as a backup plan, if everybody agrees. Disclose all offers, present all offers. And by the way, another little caveat here, handling multiple offers. You're the listing agent. You've already got 10 offers, very real situation in the last couple of years. And it still happens. Multiple offers are still out there, still happening. But you get a call from that agent that you had back when you were in pre-licensing with that weird instructor that had all those lights and stuff, and he kept coughing in the microphone. And you bonded with that fellow pre-license, and they say, hey, remember me? We went through that tough time together. You know what? I'd love to have a cross sale with you. What is it going to take for my client to win, to be picked above all those others? How much do we need to wink, wink offer in order to beat out all the other ones? Can you tell them that answer? Can you tell them the most? Be careful with this one. I know what you're going to say. And you're kind of right. But if the question is this, can you disclose how much the highest offer on the table is? If that's the only question, then the answer to that question is yes, you can. Because they didn't talk about whose permission you need. Thank you very much, Janina and Ashley. Yeah, you can answer it, but are you going to ever be given the permission you would need to answer it? Probably not. So yeah, I get why you would say, no, you can't do it, but it requires the permission of the one whose offer is the highest, and you're probably never going to get that. So you need the permission of the highest offeror, right? That's whose permission you need. But you could, if they were to give you the permission, you could answer that question. In real life, you probably never will have that permission. Therefore, you would never answer that question. And then secondly, if they call you and they say, hey, are there multiple offers on this property? What do you do? What do you do if they ask you if there are multiple offers? What do you tell them? Let me twist it around a little bit. Whose permission do you need to tell them whatever that answer is? Yeah, there it is. Ashley says, only if the seller gives permission. And that is true. What I hear in CE all the time, even from aged veteran agents, they don't know this stuff either. They say that the seller has to give permission for either one of those things, whether it's the highest offer on the table or a multiple offer situation. And that's not true. Highest offer is needed the permission of the one who made the highest offer, but this is multiple offers is what we need the seller's permission to tell. So in real life, the way I handle this one is earlier than now, back when we listed it first day. Hey, by the way, guys, if we get multiple offers, do you want to give me permission to disclose that we have multiples or not? And here's why you might not. Why might they not want you to tell the world that there are multiple offers? Why might a seller say, no, don't tell them. I don't want you to tell them. What would be a good strategy, a good reason to not tell everyone that there are multiple offers? Because buyers are sore. They've gotten beaten up. They have bruises. They have emotional bruises because they had to try like 5 other houses before they even got to this one. And they lost all 5. That's why they're here. And they thought they made strong offers, but they didn't. Something about one of those other offers was better, and that seller took it. And it happened again and again and again. And now they're just worn out. They still need to buy a house. So they're keeping on trying, but they're not as excited about it as they once were. And it wouldn't take much for a buyer to find out, oh, there's multiples, forget it. I can't bring myself to go through that again. So you'd be scaring away what could end up potentially being the best offer that you would have gotten. That's why I tell the seller it's their choice, and I also tell them why. Let's go ahead and maybe do it that way. It's their choice, but I would rather them not give me permission to disclose multiple offers because I don't want to scare off what might be the best one, right? That's offers. Broker in charge requirements. We need to have broker in charge over us. If we're going to do real estate, if we're going to have people under us, if we're going to advertise, what else? There's one more. Even a referral fee. We can't like make up little cards. We're retired perhaps. And we say, you know what? All I'm doing anymore is just getting referral fees. Therefore, I'm just going to make up business cards and say, I'm your referral agent. I don't have a broker in charge, but all I'm doing is referral. That's not enough. Referral fees count too. You can make them, you can send out referrals, but you can't proactively tell the world that you're a referral agent now. That would be considered advertising. And also, yeah, there is that. You have to have an active license to receive the referral fee. Here's some trust account stuff. We need a trust account if we choose to hold money of other people. But does a firm have to have a trust account? Firm is not required to have a trust account. Thank goodness. And firms are figuring this out more and more, because frequently, you have a cross sale with someone, you say, you've got to hold the earnest money because I don't. We don't do that. And the other one probably says, well, we don't either. What are we going to do? We're going to have the closing attorney hold it in their trust account. They have one for sure, but brokers don't have to have one. Firms don't have to have one. Nuances about the trust account. If you do choose to have one, you put it in a bank, an FDIC insured bank. That's down here somewhere. Let me see. Oh, it's over here. Here we go. Commission rule, because it's a 58A thing. That's how I know it's a commission rule thing. Here's where the outline of that is. You've got to deposit trust money. If you're going to use your firm's trust account, you got to deposit it no later than 3 banking days from getting it. Once you get that money, you got to deposit it within 3 banking days of having received it. That's sort of the general rule. But if you're a provisional broker, that's not the case. As a provisional broker, notice the next highlight part here. You've got to give it to your BIC ASAP. You're not allowed to just hang on to this money, leave it in the file for a couple of days. As soon as you get it, it's a hot potato game for you. You've got to pass it on over as a provisional broker, which can be kind of annoying, I'm sure. So maybe another reason to hurry up and not be a provisional broker. And then for a non-resident commercial broker, here's a little reference to them. They would basically have their sponsoring North Carolina firm handle the trust account for them. So they'd need to pass it on to them pretty quickly too. If the money is not currency, if the item of value earnest money is other than currency, then it must be deposited no later than 3 days after acceptance of offer. After the acceptance instead of after receipt. So normally it is currency. Therefore, 3 days following broker receipt is the guideline. But if it's other than currency, no later than 3 days following the acceptance. Yes, earnest money, the money of others, that's what you're putting in the trust account. The due diligence money is different. The due diligence money is not earnest money. It's nothing even remotely. It's the only way it's similar is that both earnest money and due diligence are credits to the buyer at closing. But due diligence money goes straight to the seller. Once this offer becomes a contract, then you, according to the contract, should get that due diligence money to the seller by that same effective date. What if it's 8 p.m. and everybody signs and communicates and you have an official contract? Effective date is today, 8 p.m. Well, you have 4 hours. Officially, according to the contract, you have 4 hours to give that due diligence money to the seller, but you're in your PJs, and so's the other agent. And you probably are going to say to each other, you know what, as long as it's cool with everybody, let's wait and handle it tomorrow. But if the seller chooses to, they could say, I don't like that idea at all. I've been burned before. I want my money today. I signed it tonight. I want it tonight. If they say that, get it to them. If you don't get it to them by midnight of effective date, then what can they do? They can't back out yet, but they can say, look, here's written notice. I'm giving you 24 hours to get it to me. And if you don't, then I'm backing out. And they have no penalties in that case at all. They have the ability to back out of the contract if you don't get that due diligence money to them within the 24 hours once they've given you that written, hey, I'm mad at you, bring this to me now, which is probably about the same time they would have gotten it if they had been cool about it to begin with. But just know that's the legal ins and outs of due diligence money. We do not put due diligence money in a trust account because it goes straight to the seller. More about the trust account. Let's see. Here's number 4. Broker can accept the possession of a check for the purpose of delivering it to the right place. Let's see. Broker may accept custody of a check or negotiable instrument made payable to the seller. We're talking about due diligence money here. As payment for an option or due diligence fee, but only for the purpose of delivering it to the seller. We need to pass that on over as soon as we can. While the instrument is in custody of the broker, we either deliver it to the payee or return it to the buyer. Broker shall not retain an instrument for more than 3 business days after acceptance of the sales contract or the option. What happens if it all goes south, if the deal falls apart? What happens to this earnest money that's sitting in your escrow account for your firm? Well, what if the parties are in disagreement as to who gets it? Sellers may be annoyed that the buyer backed out, even though the buyer has every right to back out for any reason or no reason. Seller could still be mad about it. They might say, well, I'm mad at them. I am not returning this earnest money. And you, as the listing agent, could say, well, it is still within the due diligence period. Therefore, contract says you're supposed to. I don't care. I'm not signing it. Come get it. Okay, I'm not doing that. So you have to be calm, right? If they disagree as to how it's going to be dispersed, even if they're in the wrong, doesn't matter. Your firm cannot disperse it. You can't say, well, you're wrong, seller. I'm giving it all back to the buyer because that's what the contract says. Not allowed. It says you got to have written agreement by both parties to disperse it. So that seller could, what I call, essentially hold it hostage. They could be mad about it. They could refuse to sign it. And that buyer might be a pretty money-sensitive buyer. They only have a limited amount of money available to themselves. They only have a certain amount for earnest money that if they've already used it for this one and now it's tied up, they can't get it back, they might not be able to buy until they get it back. That's why there's a way around this situation. That's why there's something called additional earnest money instead of initial earnest money that we talked about when we looked at the contract. With initial earnest money, that's the one where you have to give it over on the effective date or within 5 days. Those are the 2 time options for turning that earnest money in, by effective date or within 5 days. But what if you want to make it even later that you turn over that earnest money? That's when you'll use additional instead of initial. So just because the wording says additional doesn't mean it's adding to something you've already given. It could be 0 was initial, but all of it is additional. And that's because you can put in the date it's going to be due. You can say, we're not giving that earnest money and putting that into the mix until like the due diligence deadline day. That way, if the buyer chooses to walk away, the seller can't refuse to give earnest money back. There is none. And it's okay. It was agreed upon that there would be no earnest money collected until this due diligence, for instance. Could be any date. You fill in the blank, but that would be a pretty good one as a rule of thumb to use. But if there's a dispute, got to have written release. You could eventually turn it over to the clerk of court. You can see down here, a broker may deposit the disputed monies with the clerk of court, and then they'll handle it, right? But at least it gets it out of the broker's trust account. And now they don't have to balance and reconcile this amount of money that's never going to turn into any sort of paid commission for them. That would get old after a while. We have to safeguard money and property of others. That's another thing that falls under our fiduciary duties. What do we have to do to set up a trust account? Well, it's got to say that it is a trust account. It's also got to be, here it is, FDIC insured institution. Got to have the word trust account on the check so that you know that that's what it is. And it's got to be immediately available So you need to be able to, if the real estate commission ever came down and said, prove it, let me see how you're doing with your files. We want to see your trust account. Got to be able to produce that immediately. Can't commingle, and the broker in charge is ultimately responsible for it. Broker in charge can delegate to the office manager or whomever they want to handle the day-to-day, but they are still responsible for it having been done properly. They probably want to at least take a peek once a month, I would think. So because it's their shoulders on which it rests. And there it is, the note. BIC remains responsible for it, even if they hire someone else to assist with the maintaining of it. This little note here, disbursement and settlement agent. So there is one way you can handle it. If your firm is holding the earnest money and then you have a closing, that attorney might want to get a hold of that earnest money before they start dispersing all the other money. And if that's the case, it's just a little note here that a broker could transfer that earnest money over to that closing attorney no more than 10 days before the anticipated settlement date. There's another way to handle it that they tend to use. Instead of getting the earnest money from the broker's trust account, they just give that side's commission less this amount of money. So they can just add it. They can pull from their own trust account. They can get their commission coming from the deal, add them together, and it's how much money they are owed. But if they do it this old school way, where they write a check from their trust account, give it over to the attorney, they can't do it any sooner than 10 days before the closing, before the settlement. Talked about all that fun stuff. And then the Timeshare Act, what you need to know about this is 55510.5. What are those fives? What is a timeshare? Using it 5 times over 5 years. They have 5 days to do what? Purchaser of a timeshare has 5 days to do what? To back out. 5-day right of rescission. They can back out of it within 5 days. A developer has to hold the earnest money for how long? How long do they have to hold the earnest money for? That's the 10, right? 10 days. Hold it for 10 days. And then the last 5 is actually $500 because $500 is how much the timeshare developer could be fined by the real estate commission for each infraction, for each violation of the Timeshare Act. They also have to provide a public offering statement. The timeshare salespeople have to have a real estate license so the commission can discipline them. And they register the timeshare project as well. They also produce a plat map of the project. And then we'll go back through the slides just to make sure we hit all the highlights there. But that's what I would suggest you do with the syllabus on all these other sections too. Go down through, see what you remember, and try to fill it in, and then go back and look in your source material and review these things. So read that comment section. You've marked that up, hopefully. Read your notes on the comment section. Refer back to the license law and the commission rules. Note on safety, they want us to talk about agent safety. That's probably a little ahead of the game because I think that's a good post-licensing topic. But anyway, be safe. There is a guide for it, and here it is. And it's probably nothing that you don't already do as a grown adult. And whatever you are, man, woman, whatever you are, there are bad people out there that are looking to take advantage. Just because you're strong or weak or whatever your body type is or athletic ability, we're all subject to victimization, right? Doesn't take much for the biggest guy to be taken down if there's 2 or 3 other people who's trying to do it, right? And essentially, let's just be aware. It's so tempting as a new broker or any broker to drop everything and go show somebody a house without having made them jump through some hoops, but make them jump through the hoops. No commission is worth the danger. There's all kinds of scary stories. And this brochure that I'll put in your Google Drive shows a couple of them. some abuse, some disappearance even of brokers. We show up in our best clothes. Maybe we're driving a pretty decent car. They think we just have bags of cash in the trunk or on our own person. And people are just looking for opportunities. So just be smart about it. Meet them at the office, right? Not just at the house, especially somebody you have never met. Require that you make a copy of their license. I've had somewhere, or I've heard of some where they tried to do that and the person just kind of got mad. Well, good. Probably a good one to let go. If they won't comply with basic requirements to keep everyone safe, you don't need to work with them. And the reason they don't want to do it and got mad is probably not a good reason. More than just them being particular, maybe. Meet them, take their picture, photocopy, get their license tag, make it so that they understand this is a real business. These people are doing this properly. And this isn't just, you do it for two reasons, the safety element, but also to show them that you're not just in this casually. This is real, that your time is important. Therefore, some official measures are required. All of this could be folded along with talking about the Working with Agents brochure. And here's how I work. Remember that phrase that I love? Here's how I work. Let me tell you about who's representing who. Right now, I'm not representing you, but I can if we decide to work together. The other phrase I like, because it implies that you're not just desperate to work with everyone. You have standards. It all kind of goes hand in hand with that stuff. And oh, by the way, before we go out and look, I need your driver's license, right? You're going to need to produce that when we have a closing anyway. Need to just see some ID clearly, because there are people out there that, or at the very least, just trying to waste time. There have been people that called an agent, a desperate agent, and they went and looked at houses, never intended to buy one. They were just bored and lonely and wanted to look at pretty houses. So when they do want to become your client or look at some stuff, maybe not even try to not become your client, but the minute they want to see something, part of your procedure is this, but also, oh, have you talked to a lender yet? Right? All of this sort of folds in together. Need a pre-approval letter. We're wasting everybody's time, yours, mine, the seller's, everybody's, if you don't have what you need in place to make an offer. I just want to get familiar with the market. Business decision time. If you want to give them that leeway, that's okay. But again, don't do it at the risk of lightening up on this stuff either. Keep it safe. Background search, right? See if they're real. Go to check the social media. And then when you're out and about with them, keep that cell phone handy. If you're feeling nervous about something, make it like either have somebody on the other line, ideally, or pretend that you do. My first year in the business, one of my fellow brand new agents, we were both in class together. She did an open house for another agent. And she didn't die or anything. So this is not going to be a terrible story. It was a weird, creepy story, but not a bad end result. She did an open house. A guy came in, and usually the open houses, by the way, are not like what you see on HGTV. They quite likely are just you and them. It's not necessarily always a line of people, a big party and hors d'oeuvres flowing. It is you bored for an hour and then somebody finally shows up. That could very well be the case. So it was her by herself. The guy came in. She immediately, the bells in her head started ringing. He was weird. And she said she stood by the door immediately. She had her phone. I think she actually had somebody on the line, smart. And the guy said, well, okay, can you show me about this? She said, you take a look on through the house. She made the decision to tell him to just look through on his own. He went upstairs. He kept trying to ask questions to get her up there. But she always turned him down and said, oh, it's okay. Just take a look and we'll talk more when you come down. And then she kind of just forgot about it. He left with no incident. On the following Monday, because this was a Saturday, the broker for whom she held the open house, it was not her listing. The broker said, anything weird happened? And she had forgotten about it. She said, no. Oh, wait. Yeah, there was a guy. Turns out the dresser drawers had been gone through. The guy was up there doing who knows what. He was sorting through the personal property of the owner, and probably odds are he was kind of just up to no good. He wasn't legit there to see the house. Clearly the owner noticed that some things were out of place up there, and thank goodness she had the foresight. in the moment to stay by the door, keep it okay. But it could have gone way south, could have gone way sideways. So be careful. I'm not trying to scare you, just trying to remind you to be realistic, right? When you show houses, and you're probably not going to have them in your car these days. I'm just not. A lot of times back in the day, we would drive them around, but now everybody kind of wants to meet at the houses, and that's good. But don't pull into the driveway, right? Stay on the street, so that if you had to run out of the house because of something going crazy and jump in your car and drive off, you wouldn't be blocked in, right? And then once you're going in the house, in this brochure, it says, don't let them be between you and the door. Have them go in first, not you first, right? Keep your cell phone with you. Have a code. Another one is that. And your firm probably has something like this in place, where it says, call us if there's a problem and tell us to look for the red file, or ask for Mr. Jenkins, or whatever it is. And that means, oh, she's in trouble, because you've already told them what your plan is, what your route is, and they know to call for help, right? Open houses, good idea to do them as a team. I bet there's a number of mortgage professionals that would be glad to sit there with you, or a co-agent, another agent. Have a buddy or a spouse or loved one. Keep everything with you. Don't do them. Don't tell the world that the property is vacant, right? Here's that distress code recommendation. And then they make a note here to, you've seen it all. You've seen those ads that I've seen. People get, we want to build rapport. And so sometimes we'll tell the whole world all of our personal business, how many kids we have, what our situation is, what we're doing. We got a new car, so let's tell everybody and put that all over social media. Don't get too personal with the marketing. Sadly, sometimes, we put our pictures on things to get that connection built in, but sometimes the picture is what makes people decide to want to victimize someone. So just be very conscientious. Make sure that you're doing things that make you come across as, hey, I'm here for this real estate purpose. This is what I'm about. Take me seriously. It comes all the way back around to safety, being careful about that. And then dress properly, dress for escape. Now let's talk about the actual moment when somebody chooses to attack. Have the implement of your choice and be good with using it. Let me just say that. Whether that is a firearm or a tasing device or a pepper spray device, I'm not going to tell you not to use something. I'm just going to say be comfortable and good with using whatever it is. As you're right, you have talk to your BIC, see what their input is on that. Most things are about talking to your BIC, but don't just keep it in the trunk or in the bottom of your belongings, your briefcase, your purse, whatever you carry, and it's dusty and never touched. Make sure that you are proficient with it. Even a taser, know which end is up, where that button is. Practice these things. Practice this stuff so that you could do it in time. Have somebody time. How quick does it take you to get this stuff ready to go into action? But your main objective, take self-defense classes. You should do that anyway. Know what are the soft spots on someone's body, so that you can not beat them up and have your foot on their chest when the cops arrive to be the hero. That's not what the goal is for anybody. The goal is to run away. And the only reason you're trying to attack them or defend yourself and be physical with them is so that you can create a window of chance for you to run. You're just trying to run. If you can do that just because you get a bad feeling and start taking off, fine, right? It's all about the ability to get away. The first line of defense is to run away. There's a guy named Jocko Willink. He's a Navy SEAL. I mean, just a hardcore dude. He could take us all out if he wanted to. He's got a big podcast. There he is in the chat. Look his stuff up about self-defense. He says, if I'm out in the crowd, he's also a black belt in jiu-jitsu, which means he could choke any of us out, probably two of us at the same time. Jiu-jitsu is amazing, by the way. Take it. If you want to do self-defense, that's a great one, because most fights end up on the ground. And if you know what you're doing when you're on the ground rolling around with somebody, You could be 100-pound person against a 200-pound person and know the weak spots and how to leverage, twist a joint, and that could give you that window of chance to scramble away. Know these things. So anyway, his advice is this: if I'm in public or something and somebody's trying to start trouble, my first goal, big bad black belt Navy SEAL guy, my first goal is to run away. I got nothing to prove. I don't want to get hurt. I don't want to get sued for maybe taking them out, slamming them on the concrete. I don't want to do any of that. I'm not trying to prove anything or be a hero for my own self. I'll defend someone else. I just want to get away though. Not trying to get in fights. And that's what we should carry away with us here, right? We're just trying to get home to our loved ones. That's what it's all about. Yeah, Krav Maga is amazing. Krav Maga is an Israeli self-defense, military-related sort of martial art, better than like a standard karate where you get all the million belts, because it's all about the unfair advantage. You know, it's sort of like street level, street fighting. What's it going to take to win for life or death's sake? Krav Maga and jiu-jitsu is a wonderful combination when it comes to self-defense, or at least take self-defense classes from people that are good at these things. They will show you. You don't have to take 5 years of jiu-jitsu or Krav. You just need to take a self-defense class from somebody that shows you the Cliff Notes version, you know, necks, jugulars, eyes, and then just being in practice, because it's kind of weird to think about poking somebody's eye out, and kind of weird to think about sticking something in their side and shocking them. But you got to have that mental clarity to be able to perform in that moment, because it's crucial 2 seconds that you might have, if that. Darnell, you're martial arts, you're a trainer, but are you martial arts as well? Probably Krav, I would imagine.
I train in Krav, but I am a personal trainer as well.
Yeah. Yeah. You have anything about self-defense? Any
Do I
words?
have anything?
Any words of wisdom?
Yeah, like you said, you just want to get away. That should be the only thing on your mind.
Yeah. That's it. That is it. Let's get away to a break, and I'll see you back in 10. Thank you, buddy.
Welcome.
This is gonna kill me, but I won't let it. And I try to give them hell, but they don't get it. So I tell myself when I sleep at night, oh,
Don't lose sight, baby, don't lose sight. 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 All right, let's go.
don't lose sight, baby, don't lose sight. Don't lose sight, baby, don't
We're not gonna lose sight.
Don't lose sight, baby, don't lose sight.
Are you kidding me?
Welcome back. Hate to interrupt those guys. Man, that song gets me pumped up. Let's look at a couple more slides about this license law stuff. Then we'll take a look at the comments section and look at some examples of willful and negligent misrepresentation and omission. Make a little note here. Oh, yeah. I knew PowerPoint was trying to get me again. I got it, though. We win. There we go. Okay. Don't forget, in the comments section, there's a section on material facts we'll look at firsthand in just a moment. So, what is a material fact? 4 different things actually apply to material facts about the property, something about the property. If I were to ask you, I won't. We're just going to kind of scoot on through this. What is a material fact? I think somebody would probably say like a leaky roof or the heating and air system's not working. And that is true about the property, things that relate to the property as well, though. Down the road from what affects the property, what's close enough, not the leaky roof, but the fact that a landfill is around the corner and you might could smell it. Or the speedway coming up on, gosh, when is the race? It must be, I think maybe next weekend. I'll be able to hear the entire race at the Charlotte Motor Speedway because I'm in earshot of it, right? And there's a neighborhood even closer, and there's a drag strip over there too. I had a friend at the coffee house. He went firsthand to the drag races the other day, stood like extra close at the fences, and woke up with blurry vision, and he had popped a vessel in his retina from the concussion of those drag racers. Crazy. Put a little perspective in the thing. Well, I could hear it. I didn't know that he was there at the time, but I can hear when they're doing it. And I need to sell my house to somebody. I better make sure that the person knows that the drag strip is nearby. That's a material fact related to the property. What about the party's ability to perform? Principal's ability to complete the transaction. It could be a couple of things. What's an example of what material fact could be that affects a principal's ability to complete? What sort of material fact might that be? Yeah, did their loan get approved? Maybe you find out the week of closing that after all this work that the buyer put in, sending documents to the lender ultimately said no. You're the buyer agent. You find out from the lender that they're not going to approve your buyer for this thing. You better tell that other side. You better tell that listing agent ASAP that the buyer did not get approved. That's a material fact. Now, in real life, what's probably going to happen is they, along with everybody else you know, is going to say, what about this lender? Did you talk to them? They've worked miracles for me in the past. When I've occasionally had trouble with a loan going through, it has usually worked out. Another lender was able to pull some kind of a miracle because maybe their investors didn't care as much about the thing that caused that other one to not approve it. So don't worry. It's not the end of the world. Your BIC might be able to help you get through something like that. But that is a material fact. Another one is, did the seller get a foreclosure notice in the mail? During this under contract period, if the seller gets a foreclosure notice, that is a material fact because now a time frame is involved. That foreclosure notice says the court date is going to be on such and such. Now the clock's ticking. What if the seller tells you, the listing agent, halfway through the under contract period, they've never mentioned it before and you never knew about this, but they say, oh, by the way, I'm 4 months behind on making a house payment. Is this a material fact? They tell you they're 4 months behind on making the house payment, and they didn't tell you till now. In fact, the lateness of a house payment is not a material fact. It is not a material fact that they're late making their payment. It's only a material fact if a foreclosure notice arrives. Now, it's important, good to know, and we do want to talk about that back when we listed it, hopefully, but sometimes they don't tell you. The logic there is they could make up that house payment and nothing's going to change. As long as they haven't gotten the foreclosure notice, as long as they can pay those payments back, everybody's good. But that is not a material fact, just being late on a mortgage. Must be disclosed, or we, the licensee, is guilty of something. Some version of misrepresentation or omission, depending on our involvement. Oh, by the way, a fourth one that's not on this slide that is also a material fact is anything important to the client. That client came from Florida, where termites are the size of Volkswagens, and they're scared of termites, and they come up here and they say, I'm not buying a house that has any bit of termite on it. And they find out it had some termites who nibbled on it for 2 seconds and then went away, and nothing's wrong really. It's just a little bit of surface damage. They choose not to buy it. Well, the fact that they don't want to buy a termite house is a material fact for them because it's important to them. So you are responsible as a broker for that as well. So what are these things? Misrepresentation is something that was said or written. You actually conveyed it, passed it along. Omission is that you kept your mouth shut, nothing was said. You either kept your mouth shut on purpose, which would be willful, or you kept your mouth shut because you didn't know that you were supposed to tell it. Both of them are not okay. Both of them are going to get you in trouble. But the difference between misrepresentation and omission, either didn't disclose, didn't say anything, or you said something that was wrong. And then, did you do it on purpose? That's a lie. Willful misrepresentation is essentially a lie. Margie shared that with us the first week. And then negligent misrepresentation is you should have known about it, but you said something wrong, or negligent omission. You should have known about it and you didn't say anything. We have a reasonable skill and care responsibility. We have the duty to discover and disclose. That's why you want to align yourself with a good BIC, a good firm that's going to train you and help you figure out what resources you have. I don't know everything. Margie and Renee don't know anything either, but we know who to ask. We know who to refer and point our client to when we need it, right? That's all you need to know is who to know and how to find somebody. You're not going to have a go-to inspector from the first day. You're not going to have a go-to heating and air person or a plumber or a closing attorney, settlement attorney, but you're going to build those things up over time. They're going to be in your Rolodex. They're going to be resources available. That's why I always suggest you meet appraisers at your listings when the appraisal happens. Set it up so they have to reach out to you so they can't come appraise it without you knowing. That way you're going to meet them and you're not going to be a pest. You're not going to try to do a sales pitch and say, please appraise it for this value so I can put food on the table. No, they don't care about that. You're going to say, hey, I'm just here to let you in the door. By the way, I got a package of information for you, the features and upgrades for when you're done, but you do your thing. Let them lead the way, do their thing. They'll walk the outside, they'll measure, they'll come inside, they'll make notes of whatever they need to look at. Then they'll probably come seek you out and say, oh, can I ask you a few questions? Because it's going to make my job easier if I can just get it straight from you. Because they're not shying away from talking to you. And at that point, you say, here's a manila envelope with some pages of features and upgrades I made for you to make sure you don't overlook anything, because I want to get full value for every little possible thing we can get credit for on this thing, right? We want to make sure it appraises, right? And that is okay. It's allowed. It's actually encouraged that you meet appraisers at houses. What they'll also do, if you do it right, that appraiser will say, you know what? You've been pretty decent. You haven't been like some of the other brokers I've met that were really kind of pushy and salesy. You've been cool about it. Here's my card. Call me if you ever have questions. That's what you're there for. Besides making sure they get full credit where it's due to give as much value for this house of yours, this listing of yours as you can, You're also there to make the connection so that next time you have a listing appointment for that neighborhood and you're not sure how to give a value for a 3-car garage instead of a 2, maybe you could call this person and say, by the way, trying to list a house, how much would you give for an extra garage? And it'd be nice to hear from somebody who's actually studied that market, that neighborhood, to tell you a garage in that neighborhood's worth about $11,000 for adjustment purposes. We're not talking about that's how much it would cost to build a 3rd garage from the ground up. We're talking, how do we compare a house with versus a house without? We add $11,000 to it, to the one that sold down the street. That's the kind of information I'm talking about. So that's how you get good at valuation. Now, here's what Margie said. Willful misrepresentation is just a lie. You intentionally told the wrong information. Negligent is that you didn't check, you were lazy, you were slack. You told something that wasn't true. You didn't tell it because you were trying to lie to them. You told it because you didn't go do the work and find out the answer. You just gave them an answer, or an answer that you thought was right but really wasn't. Could get you in trouble for negligent misrepresentation. By the way, this thing is something we saw in the comments section that people could be guilty of when they intentionally overprice a listing. People have been disciplined for willful misrepresentation because what I say is they bought the listing. They went in there, they knew from their research that it was worth $440 to $450, somewhere in there. But the seller says, you can just turn right around and leave if you're not going to list this for less than $500. I'm sorry, if you're going to try to list this for less, I'm not taking a dime under $5. And if they just go along with that and say, well, my research says $440, and they don't say that, if they take that listing knowing that it's not worth it, by a certain amount over, the commission says you're lying about stuff, and that's not okay. You're deceiving the client. But people do it all the time because they want that listing. They know, well, okay. They think to themselves, I'll take it for $500. I know it won't sell for $5, but I'll just show them that I'm going to work hard. And maybe in about a month, they'll get tired of no showings, and I'll wear them down. I'll get them to come on down to maybe $475, and then I'll try to wear them down more and get them down to $450, and eventually it'll become a sellable listing. That happens all the time. But a certain level of this type of thing happening could get people in trouble. It's officially considered willful misrepresentation if you're doing it on purpose to get a listing. And then these guys, willful omission, you knew about something, but you kept your mouth shut, right? You knew that a road was coming through and it was going to get noisy around here, and this client specifically told you they like the peace and quiet of this country, but you know that sometime in the next 6 months to a year, they're going to break ground and they're going to end up putting the next overpass, the next off-ramp from 485 through this road. You kept your mouth shut because you want to hurry up and get this closing, get paid, get your commission, and sail off into the sunset with this $15,000 commission. Willful omission. You knew about it. You failed to disclose. Negligent means you didn't even bother to find out to begin with. It was important to them. You didn't find out. Some other things we're not allowed to do that we'll see in a moment when we look at the comment section is lying, false promises, right? It's not a lie. I just didn't fulfill the promise. Well, it's kind of a lie, right? Making promises the licensee doesn't keep. Paying somebody that's not licensed, not allowed to be paid, not knowing what you're doing, filling out which forms to use, how to handle the business, how to handle multiple offers, how to even write an offer, how to do the negotiation back and forth. All of that falls under reasonable skill and care. And you could get in trouble for incompetence, unworthiness for the license. You need to know, and again, align yourself with good training. And then, of course, discriminatory practice from Unit 19. The federal fair housing, as well as the realtor fair housing categories, which are all the federal ones, plus sexual orientation and gender identity. Basically, everybody should have a fair shot at real estate, at buying, selling, leasing. All the things we do in real estate, let's not do them for some people but not others when it comes to these 9 classes. Because we could be guilty of it, and therefore get in trouble, get disciplined, get sued, have to pay treble the fines because it's a fair housing violation, by the way. Testable. You could be fined 3 times the amount because it's a fair housing violation. We're not attorneys. Don't draft language. Just fill in the blanks with what goes in the blanks. And violation of any rule, that number 15 that I love, know the rules. And then lying about stuff. And injunctive relief, we saw that a minute ago. I went down a different path. I forgot to mention this, but injunctive relief is basically the thing that the commission does to get people to stop trying to do real estate without a license. I had a person call me one time on a listing and he said, tell me about your listing. And I did, because normal. And he sounded like an agent. And eventually he said some stuff that I was like, an agent would know this. Why is he asking me this? And I said, are you an agent? He's like, no, I'm not an agent. I said, oh, okay. So are you working with one? Well, no, but I'm helping an investor. I'm just kind of looking for opportunities for this investor, and I'm not the one who actually would be buying it. And I'm also not their agent. And I'm like, just FYI, what you're trying to be is an agent. And there's a specific law against doing real estate as an agent without a real estate license. Just fair warning, just letting you know. He got off the phone with me pretty quickly after that because he's trying to bird dog. He's trying to act like an agent. He's got no ability to do so, but he's trying to find opportunities to then probably sell, right? Get paid for having found something for his client. And he was acting like an agent. And so the real estate commission could come after someone like that in court because they are doing real estate without the license. Some different kinds of discipline. You could have to ultimately give your license back, surrender it. In fact, if you find out that you're in trouble, sometimes you'll see in the disciplinary section that the person just said, you know what, I'm not either admitting or denying my involvement, my guilt with this, but let me just give you my license back, Mr. Real Estate Commission. You can just have it back. I'll agree to get out of the business. I don't want to be on record as having admitted to doing anything or not. Either way, I'm just going to do something else now. And so sometimes you'll see a license surrender. They're very unsatisfying when you read them because you don't get to know the details. They don't tell you what went wrong. They just acknowledge that this person surrendered their license. And then remember, it's reprimand, censure, suspend, or revoke. But the commission could give various conditions related to those things, especially the suspension. Frequently, you'll see them say, we're suspending the license, but we're going to suspend the suspension, meaning you can still do real estate, but if you don't take this ethics class, you're going to then officially have to be suspended and not do real estate for a while. So sometimes you'll see conditions for relicensing. Mixing other people's money with yours is commingling. That's not allowed. And we talked a little bit about advertising already. No blind ads. We know what those are. As a provisional broker, you got to have the fact that you're a broker, your firm, and your firm's phone number. If you're non-provisional, you still have to admit that you're a broker. But it doesn't have to be the firm phone number. It can be your own phone number. By the way, if you're provisional, you can still include your phone number too, but it's got to be in addition to the firm phone number. And the broker in charge is responsible for advertising, meaning even if you're a full broker, non-provisional, everybody that BIC is in charge of has to answer to that BIC for making sure the advertising's done right. And that BIC might have some firm policies in place that say, hey, you need to run everything by me before you put it out there, which is really tempting to avoid because, with this thing, we can just fire off in the bank line while we're waiting our turn, put in a listing as a Facebook post real quick, but you better make sure it's done right. And your BIC might not want you to do that. They might want you to put it through and have them give it a look before you actually post. So advertising is the responsibility of the BIC for every agent under them. The BIC is also in charge of verifying, making sure the people are have paid their money and reminding them, look, CE by June 10th, pay your money by June 30th. Need to deliver documents to our BICs, our firms, as well as the client immediately, but not later than 3 days. Need to make sure the firm files are in order too, and they need to get these documents too, because the real estate commission could send someone down without notice, by the way. Hey, I'm here to spot audit the files of this firm. I'm going to just look through randomly and see if you're doing it right, see if you got everything in. So got to make sure you're kind of on top of that, right? And that applies to the client too. You have to deliver to the client the documents that they sign, the documents that they're involved with. When? Immediately, no later than 3 days. And keep everything 3 years, as we saw a moment ago. We saw this a moment ago too in the actual language. Have permission of both the owner and the BIC for as to brokerage fees. Got to disclose what you're earning. There's one thing that you don't have to disclose to the client. What is the one thing that is none of the client's business with regard to your compensation? You don't have to tell your client one little nuance. Yeah, the split you have with your firm. That's none of their business. The total amount going to the firm is their business, but not how much you end up with splitting with your firm. Yeah, your percentage. We can only fill in the blanks. We can't write legal language. We do this part already. All offers, present all offers. Get permission of the seller to disclose multiples and get permission of the highest offer or to disclose what the highest offer is, but probably never going to happen. Here it is. Here's the one I've been trying to remember this whole time. If you're a sole proprietor, meaning a non-entity, you need a broker in charge if you're doing any of these three things. We could probably sum these three things up into any sort of real estate, period. If you're trying to accomplish any sort of real estate as a job, then it's going to require these things, at least some. So if you hold trust money, then you need a broker in charge. If you're going to do any sort of promotion or advertising, you need a broker in charge. And if you have licensees reporting to you, you need a broker in charge. If any of these things are true, you need a broker in charge. So if you're a retiree who did business for 40 years and you're just kind of sitting around not doing real estate, but you keep the license going, and you'd be fine making a referral fee. You don't want to show houses, but if somebody asks you who a good agent is in Concord, you would refer them. You don't need a BIC as long as you're just kind of sitting there minding your business. But the minute you go out and tell the world with a Facebook post, yeah, let me know if you need a referral, now you've promoted. Now you need a broker in charge. But if you're just sitting there minding your business and they come to you, hey, I know you've done this for a long time. You probably still have connections. Who should I use in Ballantyne? You didn't go for them. You didn't go promote. They came to you. You could be a sole proprietor without a BIC, right? Because you're not doing any of these things. You're not holding trust money. You're not promoting your business, and you're not having any licensees under you. But if you're doing any of these three, you need a broker in charge. Sole proprietor just means you don't have an entity. You are all going to be sole proprietors at some point, the beginning. Once you pass this class, pass the PSI, become a inactive provisional broker, and then you affiliate with a firm, now you're an active provisional broker. You are starting life out in real estate as a sole proprietor. You might eventually choose to start an entity, and that's what you'll be then. But in the beginning, you're a sole proprietor. To become a broker in charge, we've covered this already. 2 years full-time, 4 years part-time. Complete the 12-hour course. If you declare yourself, you have 120 days to take the course. But if you go ahead and take the course, you have a year to declare yourself. You could even overlap it. You're not going to have your full 2 years full-time experience accomplished for another 3 months, but you go ahead and take the BIC course because you have a whole year to declare yourself. Those 3 months could go by. Now you're good on your experience, and the course is still good for another 9 months. See what I'm saying? When I took my 12-hour course, I had to take it because I'd already declared myself BIC, and I had a 120-day window to take it. But there were a couple of ladies in there who were both still in their provisional status. They were both still in the less than 2 years full-time range as well. And they had a whole year to finally meet that experience level and therefore be able to start their own firm, I think is what they wanted to do, and declare BIC. Now, the only difference once you become BIC eligible is to take a different kind of CE, general update. It's not the general update. It's called the BIC update. But it's no extra money. After you take that 12-hour course, there's nothing extra that it costs you. It's just a different version of the general update CE course. That is the couple little slides I wanted to share with you. Let me share. Here we go. I'm going to look at the comment section. Check out some willful and negligent stuff. Here we go. Here we are. License Law Commission rules. You are quite familiar with this. Your version of this probably has lots of marks and highlights and circles and stuff. And if you scroll on down through to about the 4th page, I think, we get to material facts, which we talked about a moment ago. What about death or serious illness of someone on the property? Is that a material fact? Let's see in the chat. Do you have to be a BIC eligible for at least? No. In fact, when you become BIC, it's the same form. You're declaring yourself BIC eligible and BIC at the same time. There's no requirement for eligibility first. You can do same time because those same requirements get you either status. But that would make sense. I totally get it. Yeah, what we're talking about is a stigmatized property. It's one of the categories of stigmatized property. Death in the property is not a material fact. What are the ins and outs of that? What if someone says, did someone die in this property? You're the listing agent. Did somebody die here? I thought I remember from a couple of years ago. It was in the headlines. What do you do? In fact, in a CE class last year, they specifically went into it and they said, you still don't have to answer it. You could say, I refuse to answer it, which in and of itself would probably cause them even more alarm. But officially, you don't have to answer, but if you do answer, you have to tell the truth. What you can't do is say, nope, nobody died. You could just plead the fifth, so to speak, and say, I'm not answering, but that's probably they're probably going to walk away, right? So death or serious illness. And what if the person dies of AIDS or HIV? Do you tell them, oh, it was AIDS, but they cleaned it up real good? No, you absolutely can't tell them they died of AIDS or HIV. That's now a handicap issue under federal fair housing. Therefore, you can't talk about that at all. I'm not allowed to disclose this. Sorry. Can't disclose how someone died. And it's because they died of those things. Another stigmatized property category is a sex offender's presence nearby. They might come to you and they might check sex offender registry and see that map, see all those little stars on that map. You can click each one. You can see the mugshot of the person. You can see how old the offender is versus their victim, which is really creepy. But for whatever reason, for a couple of different reasons, this is not a material fact. Because it could potentially harm a property owner, and somebody might not want to buy the house because they think an offender's nearby, but maybe that sex offender's not there anymore. Imagine this, a convicted felon might actually try to lie to the authorities. I'm not saying they all would, I'm just saying some might, and maybe they don't even live there anymore. They only lived there for a week and they didn't report the new address and they just left. so it's still in the registry. There's a certain percentage of error in the registry. And your client may not care in certain cases because maybe the offender was 18 and the victim was 17 and it was a boyfriend-girlfriend situation and parents found out and got mad. Not even she was mad about it, but her dad sure was. That's not as creepy as any time it's a 50-year-old and a 17-year-old, right? So, you just have to, as a broker, stay out of it. I can't give opinion on this. I'm not. If you know, then you would disclose it, but you wouldn't lie about it. But that's another stigmatized. And then finally, the other one is haunted house. Haunted house is another stigmatized property situation. On page 5, we have these 4, the big 4. Willful misrepresentation is how we start it, and it's just a flat lie. Let's look at some of these examples. An agent knows that the heat pump doesn't function, but tells the buyer that all mechanicals are in good working order. So they're lying about the fact that it functions. Here's the one I mentioned a minute ago. An agent knows that the actual market value is $225, but tells the owner that it's worth $250 in order to get that listing. That is officially commission acknowledged to be willful misrepresentation. We go on down to negligent, and we're unintentionally misinforming. We're misrepresenting, we're saying it, it's not omission, but we're misinforming them because we didn't bother to check, because we unintentionally didn't know the right answer. That's why the best thing to say, two phrases I like in this business are, it depends. I haven't seen your house yet. If they call you and say, hey, what's my house worth? Or how much will you charge me to sell my house? I don't know any of those numbers until I see your house, because you might not report to me exactly what kind of condition your house is in. It might be a big trash heap. You wouldn't say this to them, but this is what you're thinking, because true story happened to me, right? They said that they were ready to go. Shouldn't just be a little, maybe this weekend they'll do some cleanup and they can go ahead and put a sign in the yard. I'm like, oh, okay. Sounds good. Let's go do it. I'll come see you tonight at 6. And when I got there, it was the entire WWE list of action figures on shelves on the wall in the living room. And that's okay, as long as you're just living there. But when you hire me to sell it, I'm going to have some staging suggestions. That wasn't it, though. There was also the life-size Freddy Krueger and Michael Myers posters inside the front door. Again, staging, let's take those down for the purposes of selling for maximum value. And not even that was the worst. The bathroom near the tub, classic repair item, had some spongy kind of feel to it because water damage had probably started rotting that subfloor, and the linoleum was white, but it was actually kind of gray because it had mildew under it. This was not a house ready to be put on the market, but they thought it was. And if I had quoted them a price over the phone or an amount that I would charge for commission, the problem with quoting the commission over the phone is I get there and I see all that and I'm like, you need to do this and this and this. And they're like, we're not doing that. Just sell it the way it is. Well, then did I give them a commission that allows for this thing to sit for 6 months while I try to sell it because it's not sellable, but I go ahead and choose to take it? But I quoted them a commission thinking it was going to be like a 30, 60, 90 day turnaround. You're harming yourself. You're harming your client. If you tell them a price or a commission over the phone, just don't do it. Go see it. It depends. I haven't seen your house yet. Helps eliminate problems. And then the other thing I was getting around to here is, I don't know. I don't know things. I'm a teacher. I've been in this for 26 years. I've been teaching for 4 or 5 years. I know some stuff, but I don't know all the stuff. And so I've embraced that I don't know it. And so my favorite answer when they ask a question that I'm not 100% on is, great question. I don't know. Let me check on that for you. Because I don't want you to sue me about it later. Because I let ego take over and I tried to answer something like a big know-it-all kind of person. I'm not going to be that guy. Let's look at willful omission. An owner says that their house has 1,850 square feet. The agent believes it and records it that way, puts it in the MLS that way. The house is sold by a sales agent who tells the buyer that according to the MLS, the house has 1,850 feet, but the buyer discovers later they're 100 feet off. It actually is 1,750. What happened here? The listing agent did not make that representation to the buyer. They're not the one who told the buyer, but they did so indirectly. They put it in the MLS, and their wrong data in the MLS got reported back to the buyer. They initiated the chain of communication, is what it's saying here, which led to the buyer becoming misinformed, which was an indirect material fact misrepresentation. The listing agent also failed to verify the square footage. So they are guilty of that. That's negligence. So they're guilty of a negligent misrepresentation. They didn't verify square footage and they put it in the MLS. They conveyed something. They wrote it or said it. The selling agent, which we all now know means the agent helping the buyer. Don't forget, selling ing means buyer's side, not seller's side. So that agent helping the buyer, and I didn't say buyer's agent because I don't know what they are yet. Nothing here has told me how they are representing that buyer. All I know is that they're on the buyer's side. What remains to be seen and found out is, did they sign a buyer agency agreement with the buyer, or are they a sub-agent to the seller, but they're helping the buyer, right? Remember all that fun stuff from 7 and 8? Although that selling agent communicated the incorrect info, they acted reasonably because we have a reasonable expectation that what's in the MLS is correct. So if they had no reason to doubt the data, they are not guilty of negligent misrepresentation. However, we do have a responsibility to acknowledge and recognize when square footage is a significant amount off. And so maybe 100 feet is enough that a reasonably competent, reasonably prudent broker would be expected to decipher and have a feeling, oh, wait, you think this is 1850? This isn't. This has got to be at least 100 feet off. So they would have been guilty of negligent misrepresentation. So be good at that square footage, see a lot of houses, make sure that you have a good feel for whether it's an open floor plan or not. You still kind of know within a certain amount what something's size feels like in terms of a square footage, have a house, regardless of its layout. Willful omission, an agent knows a zoning change is going to happen. It's not on the record yet, but it's coming, being decided. It could affect the value of a property, but they don't tell the buyer that it might. They want to hurry up and get this closed, and now it's the buyer's problem later. That'd be wrong. The agent has committed willful omission. They left it out intentionally, in this case, to defraud the buyer, so they go ahead and close on it so the agent could get paid. And then a little caveat here, which as a person who didn't know any better, if I was just coming in off the street and I didn't know what I already know, I would get this wrong all day long. Because to me, I'd be saying, well, I'm representing my buyer client. Why would I tell seller that their property might be worth more if something's coming in the future? But you have to do that. That is part of our level of fiduciary responsibility, some of which is even we owe to other people, not our client. We would have to tell that zoning change or a highway coming through could enhance the value of that seller's property, even if we're working for the interest of our buyer. If we're calling around to property owners nearby because our buyer wants to buy something in this part of the county, and we know that the buyer wants to buy it because they're thinking that highway coming through is going to increase the value, we have to tell that seller. We can't just say, oh, I've got a buyer who might be interested, and then keep our mouth shut. We'd say, well, there might be a highway coming through, could increase the value of your property, have a buyer who's interested if that's the case. Therefore, would you consider selling? You can't keep that part a secret, or you'd be guilty of willful omission. I would get that wrong, guys, because I'm thinking it's all fair. All's fair in love and war and real estate. So let the seller beware, but that's not what it is, right? The city's going to expand water and sewer lines to a subdivision that has always had problems with water. That's going to turn into an increase in the value of homes. The agent's working with the buyer, doesn't tell the seller of the city's decision, so they have committed willful omission, left out something that could affect the seller's decision. And then we get into negligent omission. No actual knowledge of a fact, but they should have known. Reasonable skill and care. They should have known about it because we have this duty to discover and disclose material facts. Look things up. Somebody wants to buy land. Land, for instance, sounds simple, but it's the most complicated. It's got EPA considerations. It's got zoning considerations. What do they want to use it for? And if it's surprisingly too good to be true, priced low, it's probably because it doesn't perk, for instance. One of many reasons it could be. But maybe there's no ability to build a house on it because there's no septic tank that you could put on that house because the ground won't absorb the proper amount of wastewater for the size house that somebody might want to put there. Agent lists the house for sale adjacent to a street that's going to be widened. It's very controversial. Some people don't want it to happen. It's very highly publicized. That agent should know about it. That's another reason why the referral fee is your friend. If you live in Ballantyne and you have a buyer client interested in Cornelius, that might just be far enough away that you don't know all the ins and outs of Cornelius. And if this is happening up there and you don't know about it because you're not around there that much, you could end up being guilty of negligent omission. You didn't know what you didn't know, but you're still held responsible for it because as a professional, we have to discover and disclose, right? Maybe instead of taking something that's 30, 40 miles outside of your area of expertise, you should just have referred it to a Cornelius broker and forgotten all about it. And 6 months later, you get this check and you're like, oh yeah, found money. Forgot I did this. Great. That feels pretty good. Plus you didn't get sued or disciplined by the commission. So the city finalized the decision to proceed with the project. Plans for the widening are recorded. The buyer makes an offer. The agent does not disclose the widening and says later they were not aware of the plans. In this case, both the listing agent and the one helping the buyer, or AKA selling agent, are probably guilty of negligent omission. They should reasonably have known. That's a big question that is pursued and investigated when there is a disciplinary investigation is, would a reasonably prudent broker have known this? That is sort of the litmus test against which people are judged or are investigated. Let's see, in the chat, confused why marital status is not a protected class, but familial status is. So what is familial status, everybody? What are we talking about when we say that word, familial? You got it. Familial status for the purposes of federal fair housing is we can't discriminate against someone with underage kids. We can't not rent to somebody because there's kids because we're worried that the kids are going to tear it up and it's our property, right? We're the owner landlord. We don't want to rent to somebody with kids because those pesky kids they're dirty and they're messed things up. Therefore, no kids allowed. That's illegal. So familial status is not marital related. It's just about the underage kids. Marital status is not a federally protected class with regard to what we as brokers do, but it does pop up on the lender side through the Equal Credit Opportunity Act. They can't discriminate against somebody on the basis of marital status or age or using public income as part of their income. Those are the three extra statuses for a lender under the Equal Credit Opportunity Act. Whether you're married or not can't dictate whether they'll give you the loan or not. But marital is not what we're talking about with familial. Familial is part of fresh corn. That's one of the 7 federally protected categories. Does that answer it? Or does that help any? I can't even find you. Oh, there you are. Okay. Is it cold in your house? That's a very cozy looking coat you're wearing. Are you outside? Are those literally the northern lights and you're outside in Alaska right now? Seller has 30,000 square foot commercial property that cannot be expanded under zoning laws. Buyer wants a property in the 25 to 30 range, but wants to expand for sure, most likely later, and needs something where he can get up to 50 later, but this one's going to be capped at 30. Seller does not think to advise the buyer's agent that the property cannot be expanded, and the agent doesn't ask about it. But he knows what that buyer's needs are. He knows that currently it's 30. The buyer's going to want it to be able to expand. So obviously this is a material fact important to this client. They need to stop everything and say, you know what? It's currently 30. Let me check and see if there's any problem with it going up. If the buyer purchases without knowing about this restriction on expansion, the agent is guilty of negligent omission. They have a duty to discover and disclose. By the way, land and commercial, a big difference, hugely different animal than residential. Because for one thing, litigation is sort of a common business practice, not afraid to sue somebody. Secondly, big money comes with big risk, big problems. Your commission check on something in the commercial sector might easily be 6 figures. Might take you a year to close on it because of all of the due diligence that has to be done. The due diligence list, I don't have it close by. I usually keep it. I bought one of the real estate commissioners is Cindy Chandler. She taught me and Margie both. Margie mentioned her, I think, last week. She taught us pre-licensing, right, Margie? She taught you pre-licensing too. She taught me pre-licensing in 1996. She taught Margie like a year or two before that. I'm just kidding. Cindy's been around. She knows the deal. Go ahead, Margie.
When I left California, I didn't, I waited a year anyway. There was no reciprocity. So even though I had been in the business for 20 years in California, I had to start over. So that was like 1993. And it was one
Okay.
of Cindy's first pre-licensing
Wow.
classes.
Wow.
And being young, because I was at one time very young, like all of you, and I kept saying, well, in California. And Cindy Chandler just said, why don't you go back to California?
That's Cindy. She would say it.
And guess what? I shut up.
I'm sure she's heard that a million times from a lot of different people from a lot of different places.
Oh, yeah. And
Oh,
you
for
will
sure.
too.
Yep. That's great. What was I even saying? Let's see. Cindy Chandler. Oh, she's in a commercial broker. She's done commercial ever since. I think that's all she's ever done. She might have done residential in her very, very early days, but she's a solid and long time sharp commercial broker. Oh, and so she teaches a CE class about commercial brokerage. One of the electives you can take for your CE elective requirement is her commercial brokerage class. And so I haven't taken the class, but I went ahead and bought the book just for fun, just to read the book, just to kind of see what I don't know for commercial. In the back of the book, there's an appendix of all the different due diligence lists of things to check when it's a commercial sale. And guys, it's like 8 pages long. We could probably squeeze a couple of pages out of the residential things that we need to check, but not like that. Commercial is a lot. So anyway, big time. If you want to get into commercial, great, do it. But surround yourself with people that can teach it to you properly. I think the path for most people into commercial is they start residential and they do a few commercial deals. But you also want to make sure, again, your BIC knows what to do for commercial. I think you can look up cindychandler.com and see everything you need to know about Cindy. Again, she's also one of the actual real estate commissioners who's on the board right now too. False promises. An agent makes a promise that is not true. False, likely to influence, persuade, and that is illegal. Promising a property owner that if they list with them that they will have all the carpet steam cleaned and then failing to have that done, that's a problem, obviously. We'll look at some more problems when we come back from our break. I'll see you in 10. We're back. Welcome back. One more hour, not even that. Okay. Let's make our way through the rest of this comment section. Be thinking about questions. Obviously, now in our last class together on Monday. Oh my gosh, what are you going to do without me? You're going to be so sad, guys. I'm just kidding. Maybe a little bit. I'm going to miss you guys. You've been great, by the way. You've been helpful. You've been participative. Unmute and let's tell everybody that we love them and we're going to miss them. Go ahead and unmute. Let's hear
I
human
think you're a
voices.
great class and I will miss you and I'm crying.
That's good.
We're gonna miss you too, Miss Margie and Neil.
Thank you. Thank you.
We'll just hop on another class.
There you go. Just doing it again. Just for fun.
Thank you guys for being such good instructors.
Oh, you guys are great. You make it easier.
Thank you so much.
Yeah.
Thank you,
Thank
guys.
y'all. I appreciate it, y'all.
Thank you, Margie.
I
Well-
look forward
It
to the
was
post class.
definitely a pleasure.
Yeah, we do too. You keep us in mind for the post classes. We've got some stuff coming up this year. We're going to be putting some stuff on the calendar for next year. And oh, by the way, I put a little note in the Notion because I'm awful at this. I always forget. But if you do love us a little bit, let the world know if you wouldn't mind finding your favorite review spot on the internet. Could be Google review, for instance. If give us a little note, put some sort of a review on there for us so that we can use that in our marketing, please. That'd be great. Let's keep going and talk about undisclosed dual agency. We've already touched on that when we looked at some stuff earlier, but we need to make sure everybody knows who we are representing. And if we're representing more than one in a transaction, but they don't all know it, that is undisclosed dual agency. Another way this could come up is when we're dealing with a for sale by owner, and what we are is a selling agent. We're helping that buyer, and the buyer wants to buy a FSBO. So we reach out to the for sale by owner and we go meet them. And in the beginning, they're kind of guarded, right? We're trying to get out there face to face to see if this house is going to be a good fit for our buyer. But what we also want to do is make sure that seller might be willing to pay us. We're not asking for the same we would ask if it were a listing commission. Bye, Margie. Take care. Be careful. Be safe. We're not asking for whatever that might be. We are asking for a buyer agent commission. A commission to be paid as a buyer. And maybe, who knows what that is? It's a negotiable number too. So maybe if we would normally charge 6 to list, maybe we'd be okay with 3 or 4. If it's a for sale by owner, what I can promise you is you're probably going to be doing more than you normally would as just a buyer agent, right? When you get paid as a buyer agent on anything, you're getting paid to help your buyer through this thing. But when you're involved with a for sale by owner, you've got to do some stuff to help them too, because by helping them, you're helping your client achieve their goal. And you do all of that without letting that for sale by owner ever think or assume or imply that you are looking out for them at all. You've got to be very clear to them from the beginning. Look, I am not your agent, but yes, I can provide you with the disclosures that you need to fill out. I can guide you through filling them out. I can provide the paperwork for the offer to purchase. I can show you what the ins and outs of it are, but I can't give you advice about any of this stuff. I can even show you comparables, but I can't give you advice because I am not your agent. And if you did just let them go ahead and fall in love with you, which they're going to do because you're so darn likable, right? That's why you're interested in this business, because you're a people person to some level, even if you're an introvert like me. I'm an introvert by nature. I'm an extrovert by necessity, but I know how to love on people, make them like me. I'm not trying to make them like me. We're just we look for things we have in common, right? That's what we probably all have in common here in this room is we're pretty good at the small talk, maybe, right? We're pretty good at starting a conversation with that server in the restaurant or with that person in the grocery store line. So that for sale by owner, after the initial meet, when they're kind of guarded, they're probably going to start to kind of like you. But it would be a mistake. It'd be wrong. It'd be violating this particular provision if you just let them like you and let them start treating you like you're their agent and you acting like they're a dual agent, looking out for them at all. So that's sort of where this also applies. the example here brings up a couple of vocabulary points that I want to point out. So let's look at the example. An agent with firm Y assists her sister in purchasing a house listed with firm X without advising firm X about the relationship. We need to tell the world if our client is our relative, because that has its own conflict of interest. Sort of, hey, we need to know that the agent actually loves this client more than just what the normal fiduciary level would require of them to love them, right? If an agent doesn't disclose the fact that they are a parent, if they're the child of, if they're the sibling of, then they violated license law and the law of agency. Her allegiance lies with her sister. She should, since her allegiance lies with her sister, the agent should act as a buyer's agent from the outset. This would be true even if there was a close friend or business associate or any sort of special relationship that could influence. Another one here that people actually get wrong out in the wild is self-dealing. We as brokers cannot self-deal. We can't put our own interest above that of our clients. Whether it's you on a listing appointment and you're going through the house, and as the seller is telling you all the stuff about the house, thinking they're going to be hiring you to list it for them, and getting down to the part where they talk about what they would actually take for it compared to what they want to ask for it, because what they would settle for accepting might be a lower amount than what they want to start out asking. But then along the way, you realize, I love this house. I want to buy it. It would be wrong to keep your mouth shut, to not let them know that you might in fact be the buyer. You just want to find out what you can dig out of them, what they might be willing to tell you. Then you'll admit that you want to be the buyer after you already know that they want to list it for $425, but they would really take $395. That'd be something you could be disciplined for. Self-dealing, putting yourself above them. Anytime you put yourself and your chances of making a commission above the client, that's self-dealing. Representing another broker without consent, without the express knowledge and consent of the broker with whom they're associated. We can work for one company, more than one company, but we have to make sure the brokers in charge know about it. And I think we've already mentioned that. It could be that you are in Wilmington for part of the year and Charlotte for the other part of the year, so you have a different firm at each place. Long as both those brokers in charge know, that is okay. Improper brokerage commission. We can't pay unlicensed people. We have to be aware of our assistants that we hire, make sure, are they licensed or not, right? Can't pay commissions to somebody who aren't allowed to earn commissions. Unworthiness and incompetence, we saw some of that. Improper dealing, dishonest and fraudulent dealing. Go back through these things on your own, read these examples, get good with them. Give this at least one more read through before next Wednesday. Questions from you guys at this point? We talked about advertising. We talked about delivery. We talked about fees and compensation disclosure. You can even tell me privately in the chat if you want to. What we're also going to do on Monday is more of this. We'll review more than just the comments section. We'll review like agency and commission and sales, offer and acceptance. This is all fair game at this point. We're just making this tailored to what you guys need. And keep putting in Notion any sort of questions from the various practice exams.
Neil, I have a quick question.
Hey,
for
sure,
you.
go for it. Yeah.
That appendix we covered yesterday about measuring square footage.
Yes.
Will any of that appear on the end of class test or the PSI?
It could. Yeah, there is some square footage related material. And let's take a look. If you have a question like that, then let's see here. Yeah, definitely. That's a good one. I'll recap in the life estate thing. I'll show you some stuff about that. Okay, let's see here. It's in chapter 8. that they mentioned the measuring. So let's look at it in the syllabus and start from there. There we go. Boy, I'm going to pretend like I was that good, that I knew exactly. It's just sort of one of those things that fell out of the sky. I guess it defeats the purpose if I may as well not pretend I admitted it now. But here's what you need to know from the square footage guidelines that we covered on Monday. It's calculated on exterior measurements. Differentiate between above and below grade. Make sure you specify heated living area. It can't just be the square footage of this house is 2,000. Got to specify how much of that is heated versus not. How much of that is finished versus not. And how much of that is above grade versus below grade. What else? Gosh, I thought that was a larger section than it is. But we also recapped it a little bit today. So what's the rest of it? Knowing that the 5-foot mark on a cathedral slanted ceiling, don't measure the floor all the way to the far corner, but instead stop at the 5-foot height mark. That's how much of that room you can count. And then anything with 7 feet of headspace, ceiling height or more is what you'll count. You can do a little less. Maybe it's a basement that's finished and you're trying to report the finished heated living area in the basement, as long as it has at least 7 feet, but basements tend to have piping and duct work. And so as long as that amount is not less than 6'4", and most of it is still 7, that can still, entire room can still be counted. But that's about the gist of it. And how to handle stairs. The fact that the space under the stairs counts as square footage on the first level, and the stairs themselves count as the square footage on the second. All of that just means measure the first level and multiply by 2, essentially. Discounting for the fact like garages and storage closets that aren't heated, but that's about the gist of what you need to know for square feet. Oh, here we go. Square footage is not a material fact in North Carolina. Must be accurate if you do report it. We need to have an expertise to measure and calculate and report it. We can hire someone else to do it, but we still have the responsibility for the accuracy. We should not rely on these things: tax records, blueprints, plans, earlier transactions, the historical MLS of some other person that listed it last year. And as a selling broker representing or helping the buyer, whether as a buyer agent or as a sub-agent to seller, we have an expectation we can reasonably rely that what's in the listing is okay and correct, unless there's a significant enough difference that we should just know. We should know if we're seeing something that's 100 or 200 feet smaller than what it really is, what they're saying. Oh, there's that phrase, prudent broker. Again, be obvious to a reasonably prudent agent. And some calculations. We'll review calculations. We can do that today and also Monday if you'd like. Let's see. In the chat, we'll talk about life estates next. Yes. Someone asked that they said they got the Learn, Test, Pass practice questions. They've been studying those, taking lots of practice tests with those. And keep in mind, that's who we're going to use for your end of course exam. So that might be a pretty good resource to use. You have to pay for access for a certain number of days. You pay a certain price to access their test bank. You could just do the national portion. I think there's 800 in that, 800 possible questions. There's also a state portion. Yeah. That's good. Plus, there's an explanation for those questions after you finish the exam. What do you mean, Twee, about the PSI? They're pretty close. What they ask and the way they ask it seem to be pretty consistent with what I've been told that students are seeing on the PSI. We're not allowed to talk about actual specific questions. The practice test I was talking about was the one given by Learn, Test, Pass. Access to their bank of test questions. LearnTestPass.com. That's the same company that will be that we will be using for your class exam, but they're pretty good at writing test questions that are going to be similar. But there's also the PSI. You can go straight to PSI, their website, and you can see some practice exams through them as well. So either one, both, either or both are good to use in your preparation.
Neil.
Yes.
So with Learn Test Pass, do you choose the questions that do they send you a set of questions?
No,
or they just
I've done it myself from time to time, just so that I'm thinking in terms of testing questions. And you pretty much tell them how many questions you want them to ask you, and they will pull randomly from their bank and set up a nice little practice test just for you.
I think I've done almost all of them.
Oh, you think so? You've seen some recaps?
Yeah. Well, I save all of the tests after I do them so I can go back and practice because they have an explanation. So I think I've literally done every question.
Great. That's great. That's obvious because I've been impressed by your participation. I can tell that you've been picking this stuff up, and so apparently that's been working. So good job.
Yes. Thank you. Thank you.
What's more useful, the class exams we've given you versus Learn Test Pass? You know, the more reps, the better. These are exams that we've used for many years, and they're solid. But Learn Test Pass is just more of the same, right? But it's nice to see some different wording, right? If you've been studying these 5 or 6, then you got it down to where you know just by sight, oh, this is the one where it's the third one down. Not necessarily because you read the answer by this point, because you've seen it so much, you've gotten familiar with the look of it more than the content of it. So it might be a way to freshen up and challenge yourself again, right? Our brains just work that way. Let's look at the life estates. There, let's see here. Oops. I'll get my act together here in a second, I promise. Looking for my just start fresh. Here we go. Oh, that's what it is. Okay. There she is. It's hiding from me. Get this iPad going. There's that thing. Okay. So what we're talking about with the life estates is all part of this thing called freehold, right? Freehold instead of leasehold. Freehold meaning ownership. Non-freehold is renting, right? It's that kind of possessory interest, we should say. So all of this falls under freehold estates. And you see what I'm doing here? I'm sure you've done this by now, and I would suggest you keep doing it. I'm going to recreate the chart. That's all I'm doing. So in my limited photographic memory, which is like a 1% photographic memory, there's 2 categories under freehold. What are they? You know them. Which 2 types of freehold estates are we talking about? The kind on the left and the kind on the right from that chart we looked at. There it is. Inheritable and non-inheritable. Can you pass it to your heirs or not? How many are under the inheritable? 3. And then there's 2 under the non-inheritable. So under the inheritable, the very best possible kind of ownership with with 0 conditions is what? What's the best one on the far left of the chart? Some kind of fee simple. It's absolutely the best kind. Oh, look, that's convenient. Fee simple absolute. Put a little box around that. Not much to say about this one except that it is the best possible way. If you have a choice, own it this way, because you don't have to do anything that someone else tells you to do. You can do with it what you want. You are still subject to zoning rules and laws. You're still subject to deed restrictions. But as far as what you can do with the property with regard to the previous owner telling you, I don't want you to use it as this, or I do want you to use it as that, or the lifespan of someone else, none of that applies here. Fee simple absolute gives you no restrictions or conditions like that. The first one that does give you some restriction is fee simple something else. Fee simple, what is it? Now, there it is. That's the word I was looking for. If I could rename everything, I would not use the same first letters of major categories, right? Because it's so easy to get this wrong. What we're looking for here is this word, fee simple, defeasible. And I want you to remember it like defeatable. It can be defeated. You could lose it. You get it, you buy it from a seller, but that seller says, I don't want you to sell alcohol on here. And you're like, come on, Grandpa, get over it. This is the modern days. I'll just let you go on off into the sunset. I'm going to buy it. And then you'll forget that you even told me that next year. And then I'll start the bar and grill where I'll sell beer, right? If they do that, they could lose the property. It could go away from it. It could be defeated. And there are 2 kinds of fee simple defeasible. There's the kind where they say you must keep using it as a certain thing, which is fee simple defeasible determinable. It could be that full 4-word phrase, determinable. And then the other one is you must not use it as a certain thing. Fee simple defeasible. Oh boy, here we go. Subject to a condition subsequent. So I just remember these 2 as the long version and the short version, like the big long thing, name of a thing, and then the lesser long name of a thing. This one is you must keep using it in a certain way. And an example, tell me some examples. What might be an example of must keep using it in a certain way? Yeah, church, school, farm. Got to keep using it that way. And then this other one, fee simple determinable subject to a condition subsequent, is that you must not use it as a certain thing. And an example there would be, I always use it, selling alcohol. I always use it. Always using that alcohol. Now, that wasn't the question. The person who asked me this in the chat said, tell me about life estates. So we got all this out of the way as a review. We're good on this. Now, the next thing up here is a life estate for the life of another. It's the one that's French. Pour vie. I'm not French. I didn't take it. I took Spanish. I don't know how to pronounce it. And anybody who's remotely had French or French Canadian connections, you probably just rolled your eyes and are scratching them out because of how I said that. An estate for the life of another is what we're talking about. That is an inheritable life estate. There's 2 kinds of life estates we looked at. For the life of another, and then this one over here on the non-inheritable category, which is a conventional life estate. Those 2. Let's turn to a nice clean page. and talk about those two. Now we're looking at life estates. We're looking at the pour V, which means life of another. And we're looking at the conventional. What do they have? What are some differences? Conventional is, first of all, not inheritable. Pour vie is inheritable. How does this work? There are some players in this little situation here. There is what's called a life tenant. There's a measuring life. There is a maybe, there might be a remainderman, or there might be a reversionary interest. It's going to be either or of these two things. And then, of course, there's a seller. So you've got some players in this game. With a estate for the life of another, let me get some power going to this thing before it doesn't die on me. Sorry, 1 second. For an estate for the life of another, tell me, is the life tenant the same as the measuring life or no? It's the life of another. So no, that one's easy. Oh, shoot. Boy, I'm doing some acrobatics, guys. Sorry. All to keep this iPad alive. Getting there. Almost there. Probably looks like I'm completely insane. Okay, good. Looks like we got power. Continue to have power. Okay. Gear, gadgets. This is the downside. Okay. Life of another means in a Part V, life of another, the life tenant is the one who gets it. They're the buyer. They're the one who owns it. They own the life estate. But the measuring life is another, someone else. So if that measuring life dies, what happens to the life tenant's ownership? Measuring life dies in a Part V life estate. Yeah, well, the measuring life is dying. The measuring life is the other person. What's going to happen if that measuring life dies? First of all, the life tenant loses ownership. Something happens to it. And what is going to happen? It's either going to go to a remainderman or it's going to go revert back to the original seller. Which one is it? Depends on how the seller wrote it up. It's the decision of the seller as to which two things happen. Which of the two it might go to. The seller sold it to the life tenant with the understanding that, okay, I'm still going to be around, I'm planning to, or my estate, my family, my heirs, we want it back when you're done using it. Not when you're done using it, but when the measuring life ends, we want it back. That would be reversionary. They would be giving them an estate for the life of another with reversionary interest, meaning once the measuring life who dies, we get it back. Reverts back to us. Or they could say, you know what? I don't have any heirs. I might be passed away by the time that measuring life passes away. Therefore, or I just don't want it back. So therefore, let's just give it to a charity. Let's give it to a third-party remainderman. And in that case, it would be a Part V, estate for the life of another. that goes to a third party remainderman upon the death of the measuring life. Right? So who decides which one, remainderman or reversionary? The seller. The seller is the one who makes that decision. What can this life tenant do with it while they own it? While they're the owner, while the measuring life's still kicking, that life tenant can do some stuff with it. What can they do with it? Whatever another party's willing to do and agree, as long as that other party realizes that what they're getting is something that could go away. In other words, that life tenant could rent it out, as long as that tenant knows that, ooh, this is a life estate and that measuring life person might die, and so I'm renting this thing from this life tenant, therefore this thing might go away from them, and therefore I might have to leave at some point. They could rent it. They could get a loan if they can find a lender willing to loan on a life estate property. That might be harder. It's not just going to be an easy loan to find, if at all. They can cut down some trees. It's 10 acres of nice forest land, but they can't just cut all the trees down. They can't waste the property. That'd be considered wasting it. That'd be clear cutting, wasting it. They can cut enough to provide fuel for the property, for instance. So there's some limitations as to what they can do, and they can still do stuff, but with whom they're doing it, that person has a right to know that this is a life estate, not a fee simple absolute situation, right? Yeah, they have to keep it up. They have to maintain it. That's good too. Good job. That is for the life of another. So these are two different people. Life tenant and measuring life is person A and versus person B. Conventional life estate, the biggest difference is life tenant is the same person as the measuring life. This is a situation where I think one example I gave was maybe a couple of farmers live next to each other. One's like retirement age and the other is younger. And the retirement age one's like, look, our kids went away. They don't really have anything to do with us and they don't want to do farming anyway, but we know you do. So therefore, we want to give you, we're going to retire from the business, but we're going to give you a life estate, a conventional life estate for our 100 acres. And so for your lifespan, you can farm this late acreage or do whatever you want with it, right? You are the life tenant and the measuring life. It's for your own lifespan. And so maybe that person that they gave that right to was only 28 years old. And so maybe they lived a nice long life all the way until they were 86 years old, at which point they died. Now what happens to it? One of these two things, whichever the seller decided was going to happen. So that seller's, when they gave it to him, when they sold it to him, they said, look, we don't have kids or our kids don't have anything. They don't want it. So therefore, we don't want it back. So we're not going to do reversionary. Let's just give it to the Boys and Girls Club of North Carolina. Remainderman. Give it to a remainderman. And maybe that charity promptly sells it, gets the cash, and uses the cash to fund whatever the charity thing is. Very real possibility there. You could also see a life estate being used when maybe it's grandma and she's lived in that house for 50 years, and let's just let her keep living there. And once she dies, then we'll do something with the property, and it's all spelled out as to how we're going to handle it. But it's good as long as she's alive. She won't have to move out until she's going to use it as while she needs it. Use it as long as she needs it. I've seen life estates kind of be formed around that kind of situation. Is that good? Good refresher there. Then the only other one that we looked at was a marital rights situation under freehold. And marital rights have to do with keeping a spouse from trying to cut the other spouse out of the will. So now we had our inheritable stuff over here. Now we're over here on the non-inheritable section of that chart. Non-inheritable. We just got done with conventional life estate, so we're done with that one. Now we're talking about marital rights. So it's in a situation where a spouse is is trying to cut the other spouse out of the will or give them just a barely nothing amount of money or interest in the estate, because they were married a certain amount of time, there's actually a chart. You could look it up. You don't need to know it, but it shows years married versus therefore how much of a percentage of the estate the remaining surviving spouse gets, right? There's a guarantee minimum per years of marriage. You're not going to be tested on that part, but that's essentially it. So the marital rights, if you're married to somebody, they can't cut you out of the will. There's a certain bare minimum that you are entitled to. That all came from that one chart. What else? What else did I miss or forget about? And this fair game, math or anything else, whatever you want to talk about. If you don't tell me something, yeah, okay, math. Well, let's recap the property tax. Want to do that one? So we got three scenarios based on time of year. And what we do, how we handle the money depends on the time of year that we closed. So one of them has to do with closing before a certain date. What is that magical date that matters with regard to property tax and closings? Yeah, there it is, September 1st. Was it before or after? First question. If it's before, we do it one way. If it's after, we do it one of two ways, right? There's two ways over here. There's one way over here. The one way we handle it when it's before September 1st that the closing is happening is because of this logic. The owner, they owned it January 1st. We're selling it, let's just say April 3rd. That's our closing date. So that owner, to be fair, should pay the taxes for this amount of time in the year, including day of closing, because seller pays day of closing. That's what we need to calculate, how many days this is. Number of days, because those are the days to the seller. We do not have to calculate this many days. You do in some of the other two, but not on this one. On this question, when it's a closing happening before September 1st, we don't care. It is not needed, non-applicable, because we're not doing anything with that amount of money. We're not collecting this amount of money from the buyer if it's a closing that's happening before September 1st. The buyer just knows that the taxes are going to start to be payable as of September 1st. All we need to make sure of is that we get this amount of money into the buyer's hands onto their side of the column for the closing statement, so they have that amount of money that they can then add to their own responsibility. Oh, it'd be this, right? Their own rest of the year responsibility, and then send the total in to be paid. That's one common mistake, common confusion point that students will have is, yeah, but we're closing before September 1st. What about all this? We don't care. What we're trying to do is adjust for what matters on closing day. This does not matter on closing day. There's not a number that shows up on the statement. When it's a closing before September 1st, what is this going to be? January, February, March. 3 months, 30 days each. That's 90 days. January, February, March is 90 days, and then 3 days of April. Plus April, 3 days worth, total of 93 days the seller is responsible for. You with me? Because for you pre-licensing, all months have 30 days. So pretty easy to count them up. And by the way, fast forward, when we are talking about closing over here, still do this part. Count seller days. Don't count buyer days, because you'll probably lose track of the day of closing if you do anything but count the seller's days. Don't try to go backwards and count from the back, even if it's only like 2 or 3. Resist the urge. It will save you grief later. Okay, we know it's 93 days that the seller is responsible for, including day of closing. We also were told in the problem, maybe they were really nice and they said the annual taxes are $5,700. Do we have what we need to know to determine who's paying what for this tax proration? I think we do. I was nice to you. I didn't say the market value was 800, the percent of that that's assessed value is 75%, and the tax rate is $1, blah, blah, blah. So we'll do that in a minute. I'll be a little bit nice. But if we're just doing this part, $5,700 for the year is what do we need to know? Per month or per day? For these problems, we need to know the daily. So 5,700 divided by 360, that's $15. And we'll just call it 83 cents per day. That's how much taxes are per day times 93 days. Now, see, I'm leaving it in the calculator. You might have cleared out and typed back in 1583. We will get a little bit different numbers by doing it that way. But you won't be tested in a way that rounding messes you up. As long as it's within a few cents, pick that answer. Don't worry, they're not trying to be that tricky with you. So the seller's portion of tax responsibility is $1,472.50. But what do we do with it? Debits and credits. Are we debiting one side, crediting the other? Are we debiting both sides? How do we handle this $1,472 that represents this amount of ownership by that seller? Seller hasn't paid it yet. They can't pay it, even if they wanted to, because it's not out to be paid yet. Therefore, we do need to debit the seller. Okay, there it is. Thank you. And we're crediting the buyer. This is a true proration. One amount taken from one, given to the other. Out of the three of these potential ways to handle property tax, two of them are prorations, one of them is not. One of the two that happens when it's an after September 1st is a not actually a proration. We'll get to that in a minute. So that's it. Some version of the answer to the test says debit seller, credit buyer, 1472 is your answer. Now, they might give you 4 choices of answers, as they do. And it might look like, erase. Can you smell the chalk? Remember back in the day, it was actually a chalkboard, and they would erase, and you'd smell that chalk dust. Okay, here's what we're looking at. The answer choices might be this: 1472 debit seller, credit buyer, 1472 debit buyer, credit seller. It might be whatever the difference between 5,400 and 1472 is. I think it was 5,400, or was it 57? Doesn't matter. Let's pretend it was 54. They'll give you the opposite number. I just dyslexic on that one. Debit seller, credit buyer, and then 3927 debit buyer, credit seller. It might very well look like that. That could be one of your calculation questions. It also could be one of your math that's not a calculation. They don't even make you do all that stuff we just did. They just give you these 2 numbers you need. You just need to know what to attribute it to whom is being charged, right? Now, that was the before September 1st scenario. Let's look at the after September 1st scenario. Now we have a closing right here. Oh, I don't know. Let's call it October 19th. Just a date off the top of my head. October 19th, we're closing. We're going to, let's say the taxes for the year are $5,700. Is that enough information? What am I missing? I got to tell you something else. You need to know, was it paid or not? Did that seller pay it? They could if they wanted to, but did they? Test question is going to tell you. So let's say that the seller has not yet paid the taxes. Okay. Seller has not paid them. No taxes have been paid. Therefore, best practice here is don't trust anybody. Collect everything the seller owes, collect everything the buyer owes, and collect from both. This is the one that is not a proration. We're going to be debiting the seller's portion, and we're going to be debiting the buyer's smaller portion. Right? I did that right? Because sometimes I forget too. So let's go. Seller's not yet paid. We're going to switch colors. Do we have enough information now? We got our annual tax, which we convert to daily tax. We can calculate the number of days because we know the closing date, and we know how much the annual tax, and we know what the seller has done. They've not paid. We have everything. So how many days are we going to calculate? Always count seller days, right? Keeps you straight, keeps you good on not losing track of that day of closing. October's the 10th month. That means 9 months at 30 days each is 270 days plus 19 days of October, 289 days to seller. So how much money is that? 5,700. I don't remember which one I gave in the original problem, so I've got to redo it. I think that was the right number. It's dollars per day of 15.83 cents. So we're multiplying these two things together. So the seller's portion is 45.75.80. We'll call it 3. That's the seller's portion. We're going to debit the seller that much. Now, how do we figure out what to debit the buyer? You could go back and figure out how many days are left for the buyer, but you don't need to do that. You can just straight up subtract the seller's dollars from the total dollars. And I just do a little calculator trick where I make it a negative and then add the total. If that's confusing, then forget that and just do whatever you need to do. So 1124 and some change, we're going to debit the buyer that amount. It's 2 debits. 2 different amounts, debiting each party their respective amounts. Good? So when the seller has not paid for the year, that's the non-proration version. When the seller has paid for the year, we do it the final way. Cool. Well, thought I had it. There's our history. That's what I wanted. We had we did our math on the dollars per day, and we got what, 15.83. So that's our dollars per day. We calculated seller days. So even on this one, this is the one where it's tempting just to calculate the buyer days only. But resist the urge. It will save you the chance of messing up and losing track of the day of closing. Seller days was, I forgot already, 9 times 30, 270 plus 19, 289 was the days to seller. But what we need is buyer days. So now that we know days to seller, we can multiply it by the number of days by the dollars per day. Seller's part was the 45.74.87. The buyer's part is the difference. So the buyer's portion is 11.25. You guys who wrote it down on paper, you're like, that's why you should use paper. So this is the buyer's version, and what are we doing with it? This is a proration. So what are we doing? Debiting, crediting, buyer, seller. It's the portion the buyer is responsible for, not including day of closing. The seller has paid up for the whole year, so we need to give them back some money. They paid for the whole dinner. We need to give them back some money, right? We're going to give them back. Therefore, we're going to credit the seller and debit the buyer's portion. Seeing some nods. We okay? Want to redo that one? Want to do a different one? Gotcha. I'm looking at faces. No problem. Let's do a different one. Sometimes the lazy part of me reusing the numbers is actually harmful. So let's do this one. We'll do this again. We'll make it November 3rd. We will say our annual tax bill is $2,400. And we'll say that the seller has paid for the whole year. Does that logic make sense? Like why we handle it the way we do when the seller has paid for the whole year? Because the seller is out of pocket for the whole year, but they're not going to be the owner for the whole year. There are, I think, what would that be? 50, I'm trying to do it backwards, 56 days. Let's do it carefully. Seller days. Let's count the number of seller's days. November's the 11th month. So the 10th month is October. So there's 10 months of 30 days each. 10 months times 30 days each month. That's 300. But we still have 3 more days in November to account for. So we're going to add those in too. So our total number of seller days is 303, right? Now that we know that, I'm going to get rid of the calculation for it. Seller days. Oops, yikes. Don't do that. Seller days 303. That's how many days the seller is responsible for. How many dollars a day do the taxes cost? Well, it's $2,400 for the whole year, so $2,400 divided by 360. $6.67 per day. Does all that make sense?
Neil,
Yes.
this might sound like a stupid question. Wait, November's the 11th month, but we're only gonna do it from October, like when you times it by the 30 days.
I'm just counting it. And that might be I'm glad you mentioned that. So let's
Just 'cause
say,
that confused me a little bit.
okay, good. Not good that you're confused, but good that I know. So let's fix that. Let's do it a couple of ways. We could do it this way: January, February, March, April, May, June, July, August, September, October, November. November is 3 days because it's on the 3rd at the closing. But all of the rest of these days are 30 each. That's why I'm spouting it off so fast. I'm like, okay, that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 months, 30 days per month is 300. Plus, let's not forget the month of closing. So I'm just doing it fast. That's why I was saying, okay, what month is which? The 10th. So that, I'm sorry about that. I'm glad you spoke up, though. That might have been throwing people off. And if this is the way you need to do it every time, that's okay too. Do it. It took us, 3 seconds. I just done this so much that it's just what I do, but it's whatever sticks in your brain is what counts. There's no right or wrong. Every math problem is probably there's 3 or 4 ways to do it. Little shortcuts of multiplying and whatever, but it's like the excise tax. There's 2 ways to do that. Pick one, do it that way. You don't need to know all the ways for everything. We okay on how the days was calculated? Okay, good. If we had 303 toes and fingers, we could just do it that way. So we got 303 seller days. We know our dollars per day. Now we can calculate the financial responsibility of the seller. What part are they required to account for? Okay, $6.67 a day times 303 days. The seller's portion is $2,021.01. But this is a scenario where they've already paid for the whole year. They've paid more than $2,021. They've paid $2,400. They paid the whole year's bill already. We need to give them back some money. How much do we need to give them back? This much. The part the buyer's responsible for. And we don't need to mess with days to do it. We can just subtract the seller's dollars from the total dollars. $2,400 total for the year minus $2,021.01 for the seller leaves the amount required from the buyer. And since the seller is already out of pocket for the whole year, we need to give them back $378.99. Credit seller, debit buyer, the buyer's portion. Is that better? I'm looking for nods. Or not. Don't have to be a nod. Better? And I mean, we're officially at the end of our time together, but I'm happy to stay around if you want to do some more of these. We will do more on Monday. Bring your questions for those of you who do want to head out. But I'm happy to stick around for a few minutes if you guys want to go over some more stuff. Because at this point, it's all hands on deck. It's the more the better, right? So I'll see you Monday. Or if you want to hang out, we can talk about maybe something like interim interest. I'll pause and see how many of you like, it's lunchtime, dude.
I thought of a question that's probably not going to be on the test. It's just sort of a realistic.
Okay.
Anyway, I'll just ask it. The houses, the house types, the architectural types we were learning. I don't remember the technical term for it, but the A-frame style house where the roof runs from the ridge board all the way down to the ground, pretty much on either sides of it.
Mm-hmm.
I know in that for calculating square footage for the attics, we do the 5-foot height, and then for the rest of the floor, we do the 7-foot height. But if we have a house like that, which one of those heights will we calculate?
It'd be the 5 foot.
5 foot.
Yeah, they don't want you to use this portion at all. So whether it's a bonus room or main living area downstairs, whatever, they're only going to count the heated living area square footage is going to be that 5 foot mark, regardless. Not probably something you'll see on the test specifically, but you'll probably see it referred to as a bonus room. But in real life, it's a 5 foot rule.
Hey, Neil.
Hey.
Can we work on discount points a little bit?
Sure, of course.
And there was a section about improper fractions, which I can't remember. It's in there somewhere.
Yeah. Was that something I told you or something you saw somewhere else?
No, it was in this class. And I made a note in my book about better understanding like improper fractions, but I didn't notate exactly what we were talking about. You
don't necessarily, I just did it that way because in that problem, they gave it to us like a rate of 5 3/4. They could have instead said 5.75. So when you see a fraction, if you're not used to converting that fraction into an improper, then just take this and divide 3 by 4 to tell you what that decimal needs to be. And then just come up with this one. And work with decimals. Don't worry about fractions. Right? But when we're talking about discount points, and we know that the investor wants to yield 6.25%, that's how much money they want to get in some way. They either want to get it in terms of interest over the whole 30 years, or they're okay with getting a chunk up front called discount points and the rest over the 30 years with individual interest on each payment, right? Whichever way, they want it to end up being a 6.25 yield, right? That's where that weird yield word comes from. But the investor, that's the one whose money it is that's being borrowed. The lender is the one who's facilitating the loan, right? It's easy to get those two and think they're the same thing. The investor is the lender. No, the investor is the one whose money is being borrowed. The lender's the one who you're meeting. They're the loan originator. They're the one who, the loan company, Rocket Mortgage, whatever, right? They are quoting a rate to the borrower of 5.75. In other words, all the payments over the life of the loan are going to be calculated at 5.75 because that's how much monthly payment you can afford, right? Therefore, we need it to be based on this. So therefore, we need to come up with whatever this difference is and charge them that in the form of discount points. That way the investor's happy. They're getting 6.25 of yield, both in the form of upfront discount points, prepaid interest, but also, good. Thanks, Renee. Also over the life of the loan for the gradual interest from each payment. You with me? So far. Okay, now let's clean this up. We're dealing with decimals. We have a promised rate to the borrower by the lender of 5.75. We have a lender yield that they want of 6.25. How much is the difference between those two things? Well, that's easy because it's decimals already. 5.75 from 6. That is 0.5%. 0.5. That's how much is the difference between the interest rate the borrower can afford for their monthly payments and the amount the investor wants. But now what do we have to do when it's discount points? One discount point, first of all, costs how much money? Whatever the loan amount is, it costs 1% of it. We know that. But for every discount point, how much does it knock the rate down? Not 1%. That math doesn't work. One discount point lowers the rate by 0.125%. In other words, right now, the rate's just reached 7%. That's what's out and about in the real world right now. Like double from only a year and a half, 2 years ago almost. 7% is what they're getting. What if a buyer who's been thinking about it, looking for houses for the last year, not realizing, oh, wait, I was dragging my feet, but now the rates are higher than I would have had if I'd have done this a year ago. I can only afford 6 3/4 or 6.75. That buyer needs to buy the rate down by 0.25, right? They need to get it down. And how are they going to do it? They need to buy how many 1/8 in order to add up to this many. And so what I've done to you now, you're like, you son of a gun. You're mixing fractions and decimals. How dare you? So that's what I'm getting around to here. What is the decimal version of 1/8? If you work in decimals, you just need to know the decimal version of 1/8. That's the only reason I used fractions that time back a while ago, because we were already dealing. I know that one discount point buys the rate down by 1/8, but this is easy to calculate too. 1 divided by 8. The decimal version of 1/8 is 0.125. So now, original question. The difference between what the investor wants to yield and what the lender is going to loan to the borrower at, the difference was half. How many 1/8 are in a half? Now that you know the decimal version of 1/8, just divide. 0.5 divided by 0.125 gives you the number 4. That's how many discount points you need. That's how many discount points the borrower needs to buy, or the seller needs to buy for them, or grandpa needs to buy for them. Doesn't matter who buys them. That investor wants 4 discount points in order to agree to let that borrower have their payment based on 5.75. Is that good? And we already know the next thing. Okay, then how much will the discount points cost? How much will 4 discount points cost? We need a little more information. We know that 4 discount points are going to cost 4% of something. What is the loan amount? That's what we need to know. Does that help? Good. Good. There's your math tutor there beside you, Jennifer. Let's see. Okay, so I went all into that. Now let's look at how it might show up on a test. Quite likely the only thing you'll see is the buyer needs to buy down the rate by 2 discount points, the market value, or let's just say the sales price. Sales price of the property is $373,000. The loan to value ratio is 90%. How much will these 2 discount points cost? No mention of the rate being bought down. How much will the new rate be? That's a whole other thing. But this is not that at all. This is just how much the discount points cost. You just need to get the discount points, which they gave you, and you need the loan amount, which you'll need to calculate by taking 373 times the 90%. I'm about to sneeze. And that gives us a loan amount of $335,700. If you want to make this a circle formula, multiply the loan amount times the discount points, which are 2 of them, which is also known as percent. And 335,700 times 2% is, good job, the amount of dollars that 2 discount points cost on a loan amount of 335,700. Right? Yay. But what if it went further and said, what if it said this? The current rate, the market rate is 7%. What will be the rate for the buyer if they buy 2 discount points? How much will the rate decrease to? What will it become? You need to find out how much of a rate decrease are 2 discount points going to be? How much does 1 discount point buy the rate down? 1 discount point brings the rate down by 1/8. That's just a thing you got to remember, like how many square feet in an acre. So 1 discount point lowers the rate by 1/8 of a interest rate percent. But there's 2 discount points, so how much is 2/8? 1/8 plus 1/8 is 2/8. Here's where we're getting into fractions again, those darn fractions. Forget about it. You know that it's 2/8. Divide it. 2 divided by 8. Boom. It's 0.25. That's the decimal version. What's 7% minus 0.25%? The rate that borrower will now be able to have their payment calculated on, since they gave them a chunk of money, $6,714 up front in the form of discount points, also known as prepaid interest, also known as yield to investor. The new rate for them is 6.75. Right? So we knew how many discount points they bought because they could afford it. It might be because they had a certain amount of cash available for their down payment, but they didn't need all of that for the down payment. They had some money available to them left over. So what are we going to do with it? Oh, let's buy some points with it. How much can we drop the rate by if we use the extra leftover cash or the gift from grandma or whatever, or the tax return refund that we got? We have this money available. What can we do with it that's going to help us the most? You could buy the rate down. You were already worried about how much you qualified for and how that's really kind of the top of your budget. True story, real story in today's market, right? Everybody's buying at the top of their budget because they have to, because the prices are so high. And the rates have gone up. I mean, this is a real world thing that popped up just last week when the rates hit 7. People and brokers on my Facebook feed and lenders are talking about how can we help buyers not be scared to buy? Well, we can start talking about discount points. If they have some cash available, they could buy that 7% rate down. 6.75 translated to a monthly payment is some amount better than 7. And if you're already at the top of your affordability, that could be enough to get it feasible, right? So discount points are not going to happen on every loan. Excuse me. In real life, the buyer may not need them at all. Forgive the plastic rustling as I open a cough drop. But what will happen on every loan is some amount of origination fee. So don't forget about that one. And oftentimes the discount point question is lumped in with origination fee. They want you to calculate how much the buyer needs to pay for 3 discount points and also the 1% origination fee. All of that combined, how much will the buyer need to pay? So it could look like this. An origination fee of 1%. 1% of what, by the way? No, definitely not always 1%. It is a negotiable number. A lender that's maybe trying to be competitive and beat out other lenders might lower that, might say, we'll do a 0.5% origination fee. It's just that you see it a lot on this test. But yeah, since we're talking anything about lender, it's all about the loan amount. So the test question is origination fee. Let's just do it that way. Let's make it different than 1%. It's just a mess. Let me try this again. Origination fee the lender is charging is 1.5%. The discount points that the buyer needs to buy in order to have an affordable rate, they need to buy 3 discount points. The sales price on this property is $160,000. The loan to value ratio is 95%. If the loan to value ratio is 95%, by the way, how much is the down payment in percent? Yeah, the opposite. Whatever 100 minus 95 is. Yeah, so it's a combination of down payment and loan amount that adds up to the full sale price. So loan amount's 95. They're borrowing 95% of the full price. So the question would then be, how much will buyer need to pay? In some version of this language, but you get the point. Can you hear that buzz? Just curious. Okay, good. It's just me that's driving crazy. It's just spam calls on my phone. Okay, so a couple of ways we could think of it. We could say, okay, discount points, there's 3 of them. We know that 3 discount points are going to cost 3% of the loan amount. And we know that the origination fee is 1.5% of the loan amount. And since they're both of the loan amount, you could save a step and just add them together and calculate 4.5% of the loan amount, and you'd be done. But I don't want to confuse you. So if you need to do it piece by piece, then take the origination fee of 1.5% and let's calculate that. But what? 1.5% of what? We need to turn this into loan amount. 160 is the purchase price times 95% is a loan amount of $152,000. So let's do the origination fee first. $152,000 times 1.5%. The The origination fee piece is $22.80. And then 152 times 3% is $45.60. And when we add those together, it's a total of both origination and discount points of $68.40. Or if you did it the faster way, where you just turned all this into 4.5%, same thing. That helpful? Good. All right, to draw it out, prolong the pain, we know the discount points are 3%. There's 3 discount points. Let's say that the rate the market rate that they get is 6.5%. If they're paying 3 discount points, what will their rate become? How much lower will their rate be? What will be the new rate after they pay the $6,840 worth of discount points? What does 6.5% interest rate lower down to? How much of an interest rate reduction is there with 1 discount point? 1/8. I saw lips moving. Good. 1/8 per point. Well, how many? What does it what happens if there's 3? 1/8 times 3, or 3 1/8 is 3/8. 3 discount points buys the rate down by 3/8. But we're dealing with decimals. We want to turn this fraction into a decimal. 3 divided by 8 is what the decimal version is. 0.375 is the decimal version of 3/8. And that's it. We're pretty much there. We just need to subtract the 0.375 from the 6.5. So that 6.5% rate that everybody else is paying is going to come down to 6.125 for us, because we paid $6,840 up front prepaid interest. Not so bad, is it? Good. You don't have to work in fractions. Just make sure you convert and use the same thing. Use all decimals or all fractions. But it's easy to convert a fraction to a decimal because you're literally dividing the top by the bottom. What else? That's discount points and origination fee. What else? Let me think. How about interim interest? Interim interest. Oh boy. Now we're thinking in terms of month, days in the month. Because interim interest is about how many days are left in the month of closing and how much money will the lender charge me for those days. How many days are left in the month of closing, and therefore how much will my new lender that loves me, how much are they going to make me pay for the privilege of living in this house for the remainder of the month of closing? Here's how that looks. We're in October. Let's say our closing day is the 24th. October 24th, doesn't matter what month really. October 24th is our closing day. And we also know that here's how loans work. If we have October, November, and December, and we're all paid up through the month of October by using interim interest, which is we're going to do in a minute. When is our next payment due? It's not here. Our first official full payment is going to be like a whole month plus away, because we pay in arrears when it's a mortgage. We pay for the privilege of living here in November. We're going to pay for that privilege on December 1st after we did it. Opposite from rent. We pay before we live there. If we were renting this place, we'd be paying November 1st in order to live there through the month of November. But for owning, it's in arrears. We pay after we did it. Okay. So that's the logic. Interim interest is the interim amount of time, the interim time between closing and end of month, because the next month is going to be covered by the first official payment, which happens on December 1st. That's why we're doing it this way. Interim interest. What do we need to know here? Let me think. Oh boy, this one can be big. Let me do the monster version. Closing October 24th. We have a sale price of $414,000. We have a loan to value ratio of 80%. We have an interest rate of 6.5%. What amount will buyer be charged for interim interest? I did a lot of mean things to you. We need to calculate our daily interest. That's what we have to use these three numbers for, to come up with daily interest. So, loan amount is what we need to start with. We turn this into loan amount. 414,000 times 80% is a loan amount of 331,200. That's how much is being borrowed. If the 331,200 is being borrowed at 6.5% interest rate, that is how much in annual interest. By the way, this looks a lot like a whole other unrelated problem. The positioning of these numbers looks like how we do annual taxes. Right? When we do that, we do a tax value here, a tax rate here, and we end up with annual tax bill. So just a little note there that the math is pretty much the same. It's a totally unrelated question, but the math relationships are the same. For one thing, the rate's always on the bottom. Times a big number equals a smaller number on top. Those things might be useful. So we take our 331,200, multiply it by our percentage. Our annual interest is $21,528. That's how much it costs for a year's worth of interest if we're borrowing 331,200 at 6.5%. Just multiply them together. No, divide by 1,000 is only for tax rate when it's mill rate. Good question. Divide by 1,000 is something you'll only do if it's a mill rate on the tax question. We just had to calculate our annual interest, and we got the annual, and if we get the annual, we can turn that into daily. How do we turn annual interest into daily? 21,528 becomes daily interest by dividing it by what? 360. So that is $59.80 per day in interest that your new lender is so happy you joined the lending family wants to charge you. So now we know our dollars per day. How many days though? Interim interest has nothing to do with the seller. This is all about the buyer's new loan. Seller's not involved in this. So this is the one anomaly where buyer pays day of closing. So the way we count the days is all months have 30 days. 30 days minus the, let me make this a little somewhat neater. Oops. Okay, whatever. Go with that. 30 days in the month minus the day of closing is 6 days left over, but that does not include closing day. We need to make sure we add in for closing day because the buyer has to pay for that day too. So the days the buyer is responsible for here are 7, because that way the closing day is included. With this few days left in the month, you can count it on your fingers, and I literally would. If I'm tired I'm like, let me just double check. Okay, 24, 25, 26, 27, 28, 29. That's 6. Whatever. Pull your shoe off if you need double digits. Of course, the proctor of the test might think you're looking for like a cheat sheet or something. $59.80 times dollars per day. Oh, sorry. $59.80 times 7 days. The amount we're charging, the lender is charging the borrower for interim interest is $418.60. It's debit the buyer, nothing to seller. We're just pulling it from the buyer. Buyer has to pay it for the privilege of living there through the rest of the month of closing. Doesn't matter after the month of closing because they'll live there in November and then pay for that privilege on December 1st. And then they'll live there in December and pay for that privilege on January 1st. On and on and on. Step 1 was coming up with the dollars per day of interest. And so that they might be nice and tell you what the loan amount is and you didn't have to do all of this nonsense, all this stuff. But if they don't, if they give you sale price and loan to value ratio, you're going to have to use that to calculate the annual interest and therefore the daily interest. So somehow you get dollars per day of interest. Then you count up the number of days, including day of closing, that the buyer's going to own it and multiply them together. This is the tricky part. That freaks people out. But just think of it as just a couple steps. Just use these two things to get the loan amount. Now we've got what we need to plug into the circle. We know the rate. Would really suck if they said the buyer paid down 4 discount points. The rate was 7. How much did the rate end up being? And then use that rate. I don't think they'd ever do that to you. To make you calculate the actual rate with discount points. No, I'm not going to jinx you. Never heard of that level of masochism being inflicted upon people. But that could be a real life thing. In real life, when it comes to anything related to the loan, you're probably going to cover your bases by saying, good question, let's talk to the lender about that. And you stay out of it. Nice to know how it works, but you don't want to give any official answers about loan stuff. Talked about tax. We talked about interim interest, discount points, origination fee. Here we go. There. This is available to you in the Google Drive. And I would suggest you scroll on down through it on your own too, but we're going to do some of this on Monday. Just a reminder of what the formulas are, both the linear version and the circle or T formula version. Mill conversion. What I'm looking for something specific. Well, here we go. If they ask what your equity in the property is, don't overthink it. All the equity is what you don't owe. The value of the property minus what you owe leaves you with what you don't owe. That's your equity. So in the very beginning, on the first day, when you put $10,000 down on that $100,000 sale price property, how many dollars of equity did you have? $100,000 sale price. You put a down payment of $10,000. How much equity is in the property? $10,000, right? Because that was your money in it. How much are you borrowing? $90,000. With me? And so then over the course of the next 5 years, the value of the property goes up to $120,000. You put initially $10,000 down payment, but you've been making your monthly payments, which adds to the part of that is toward your principal over the time. So your equity has gone up, plus the property value has increased. So your equity position has increased. So the test question might say current property is valued at $120,000. You currently you started out owing $90,000, but you paid that down because it's been 5 years of you making payments. Now, instead of 90, you only owe 83,000. So let me show it on this. You bought it for 100. It has risen in value to 120. You initially put a down payment of 10,000, but over time, over those last 5 years since you bought it, you've been paying monthly payments and buying down your amount owed, right? So the loan amount was originally 90,000. That has gone down over 5 years. Now what you owe to that lender is $83,000. What's your equity today? Now that your loan balance is no longer 90, but it's only 83, and now that the value is up to 120 and is no longer only 100, it's just subtraction. The difference between these two numbers, 120,000 minus 83,000, your equity is now $37,000. It used to be 10 5 years ago. Now it's 37. Your equity went up 27%. It was 10,000. Now it's 37. If you do that little division, that's 0.27 times 100 to turn it into a percent. So your equity went up by that much. Right? Simpler than it looks. Here's what we did just a minute ago to calculate interim interest. We had to calculate the simple interest, right? How much would the annual interest be on a loan amount that we had to figure times an interest rate they gave us? And that's all we did. Multiplied those two to get the annual and turned the annual into daily. Here's our discount points. Here's the yield. When you see yield increase, that's that whole thing about one discount point buys the rate down by 1/8. Because while the borrower is enjoying a lower rate, it's because they paid a chunk of money to the investor. That was yield to the investor. So the yield to investor is the opposite of the lowering of the rate for the borrower. Loan factor. Don't forget the loan factor. That's where, here, let me share with you. Sorry. Here's what I'm looking at. Loan factor chart. They could give you the chart, or they might just give you the factor. I feel like they're probably just going to give you the factor. So it might look like this. Sale price, $315,000. Loan to value ratio, 80%. Loan factor. It's a 5.5% mortgage on a 30-year loan. And so when you plug that into the loan factor chart, you know, they've got the percent rates down the left side. They've got the 15-year, 20-year, 30-year across the top. You're looking for the 5.5% somewhere down the list. You're going to carry it over and find where it is on the 30 column. That is the factor we're looking for, right? So that's the reason and where the factor comes from. So all we need to know is that they're giving us the factor. Let's just say that they're giving us a loan factor of 5.73. I don't even know if this makes sense numerically, but that's the loan factor that they're going to give you. Now, what would be the monthly principal and interest in this situation? The principal and interest payment per month. So remember that the loan factor is just pretty much saying for every 5.73 means for every $1,000 you borrow at, in this case, 5.5% rate for 30 years, your monthly payment, principal and interest is $5.73. That's what the factor is. It's a dollar amount per thousand. Therefore, we need to figure out how many thousands are in the loan amount. Right? That's kind of the why we're doing it this way. So back to the loan amount again. We gave you the sale price and the loan to value ratio. We need to turn that into a loan amount. 15,000 times 80%. Oops, it was 315,000. My bad writing messed me up. Is a loan amount of 252. That's what's being borrowed over time. It's being borrowed at a certain percent rate and for a certain number of years. And so when you look at it on the chart, it reveals a loan factor of 5.73. So first step, find the loan amount. Second step, turn it into how many thousands there are. So 252 divided by 1,000 is 252. 252,000 divided by 1,000, cross out 3 zeros, gives us 252. And then we're multiplying that by the factor itself. And that will reveal how much our monthly P&I will be. So 252 times 5.73 brings us a monthly principal and interest payment of $1,443.96.
This was the one with the divide by the 1,000.
Oh yeah, that's right. Forgot. Oh, good. I'm glad we did it.
So is it always dividing by 1,000?
When it's a loan factor, because the chart is given in increments of $1,000 loans. In other words, a loan factor of 5.73 means when you borrow $1,000, you pay $5.73 a month for principal and interest.
Per 1,000. Okay.
Yeah, per 1,000. Now, again, the factor is going to vary depending on what the rate is and what the years of the loan is because it's a chart, right? You're looking on the chart to see what the factor is. I don't know that they had did they have a sample of that chart in this book? Let me see here. I believe it is, let me think, it would might be chapter 8. No, it's finance. It'd be, yeah. There's a different book, and I actually have it here. If they don't show it right here, I'll just show you the other book. There it is. Okay, good. Page 337 of your book has the loan factor chart. Obviously, it's huge. It's just a little excerpt from it. And it's showing at a 6% interest rate, if that's what your rate is, and it's only a 15-year loan term, because you can handle that, then the factor you're going to use is 8.44. In other words, when you borrow $1,000 at 6% for 15 years, then you're going to pay per month P&I $8.44. So how many thousands are in the loan amount? Take that number of thousands in the loan amount times the factor number, and that's going to tell you what your monthly principal and interest is. In this case, a 6% rate for a 30-year term is actually coincidentally a factor of 6. Don't let that confuse you. There is no connection to it other than it's just a coincidence. But let's say like now the rates are more like 7%. 7% rate. I don't know if I can line this up properly. I think that's the right number. 7% rate for a 30-year loan. 6.65 is the loan factor. If you borrow $1,000 at 7% over the course of 30 years, every month you've got to pay $6.65. That's both your principal and interest. Now, what you don't know is how much of that $6.65 is going toward interest versus principal. Every month it's going to be that payment, but in the beginning, most of that's going toward interest, and by the end, most of that's coming off the principal because of amortization. So we've got a 6.8, what did I just say, 6.65. I think that's lined up right. Yeah, 6.65. Let's flip over to the the problem. 6.65. Here's our new loan factor. Again, because it's a 7% rate for 30 years. Let's be nice this time. Let's say our loan amount, I'm not going to make you figure it out. Loan amount is $567. We know our factor. We know our loan amount. What's the P&I? We need to, if you want to put this in a circle formula, it's loan amount divided by 1,000 is one of the items on the bottom, and the factor is the other item on the bottom. So 567,000 divided by 1,000 is the number 567. The loan factor that was provided is 6.65, and it's just multiplying those together. So our monthly payment every month for both principal and interest through $37.70 and 55 cents. Good. Okay. If you don't have anything else, I'm going to call it. You let me know. Put it in the, keep doing that. Keep putting things in Notion, especially this week, and we'll make sure to address them. If you have a practice exam thing or math thing, or we'll talk about agency. We'll talk about offer and acceptance, communication. At what point would it become a contract? We'll just review all the, the big stuff and anything else that individual people have a question about. But otherwise, have a great weekend. Yes. Mm-hmm.
Sorry, last question.
Okay.
Thank you for staying with us.
Sure.
I was going to just purchase the Learn Test Pass after the class exam.
Okay.
Is it sufficient, like the material that I have?
Yeah.
Like the practice that I already have? Because I just didn't want to, I was going to do it that way, but if there's a better chance of me passing it,
let's
buy it
see.
now,
Yeah,
like-
there is something to be said for making the most of your opportunity here. Let's see here, though. Sorry. It's weird. with me one moment. I lost something.